Thanks so much, Carla. And thank you, everyone, for coming today to our Global Animal Law Updates seminar. I want to start off by saying that the seminar was made possible by the Centre for Animal Law Studies Global Ambassador Program, and we want to thank them so much for their support today. So my name's Tess. I'm a lawyer from Sydney, Australia. I'm a graduate of the Animal Law LLM program at CALS at Lewis and Clark Law School, and I currently work as policy advisor to the Honourable Emma Hurst, who's a Member of Parliament for the Australian Animal Justice Party. I'll hand over to my co-host Tony to introduce himself and tell us a bit about the seminar today.
Thanks, Tess. I'm also a graduate of the Lewis and Clark Centre for Animal Law Studies, and I'm currently working for HSI Africa as the director of that organization's African operations. Today we're going to be talking about developments in animal law. It's a very rapidly evolving field. Just last week, an exciting decision was handed down in Ohio in a matter involving hippos in Colombia, no less. Across the globe, advocates for the better treatment of animals are finding innovative ways of using the law to protect animals in all sorts of different contexts. Our focus today will be twofold. We'll be looking at some of these developments from around the world and exploring how this work is happening in practice on the ground. Whilst we cannot hope in the time available today to cover everything novel, current, or newsworthy, we hope you'll enjoy this session with us as a snapshot of animal law work in a variety of different fields from all across the world. We'll be looking at efforts to end captive lion breeding and live export for slaughter from South Africa, how New Zealand advocates engineered better lives for pigs in New Zealand, how attorneys in the US are using that country's Endangered Species Act to protect wildlife in Africa. And without further delay, then I'm going to let Tess introduce our first speaker, Martina, who will share with us some insights on animal law developments in Europe.
Thanks, Tony. Before I do that, I'll just mention a few housekeeping things really quickly. So as you would have heard, the webinar today is being recorded and we are hoping to make it available online afterwards. So we'll let you know in the Facebook event when that becomes available. Also today, we're really encouraging people to ask questions of our presenters as we go. So you'll see that there's a chat function down the bottom of your screen. While our presenters are talking, please feel free to put as many questions as you like in the chat and we will aim to ask them at the end. So that being said, I'm going to start with our first speaker, Martina. Martina is a professional animal advocate and has been successfully running political, corporate and awareness campaigns to improve the legal protection of farm, companion and wild animals. Her work includes campaigns for legal reform against cruel farming practices, fur fashion, trophy hunting, dog fights and more. Martina holds both a Bachelor of Laws and a Juris Doctor from the University of Salzburg, as well as a Master's in Animal Law from the Autonomous University of Barcelona. She's currently a PhD candidate in animal law, has written a book on animal law, and currently works as Director of Humane Society International in Italy. So it's an amazing resume, and we're really excited to hear Martina talk today about some developments in Europe. So Martina, I'll hand over to you.
Thanks, Tess, and thanks, Tony, for having me. Good morning and good evening to everyone attending. I'm going to start by sharing my screen. Can you all see that? I hope so. All yes, right, I see Tess nodding. That's a good sign. Awesome. So I'm going to give you an overview of a couple of selected by me, obviously, developments in animal protection law from Europe. I hope this is somewhat new info for you guys. If not, you'll have to bear with me. No, just kidding. I've tried to select 3 topics that kind of fit in well with the most common animal law discourse, one about constitutional protection of animals, the deification of animals in civil codes, and then an interesting aspect from the European Union dimension. So I'll start with that, actually. I'll talk to you about a possible or likely ban on cage keeping for farmed animals in the European Union starting from 2027. Then Spain moving towards removing animals from the category of objects in its civil code. And then Italy moving towards a constitutional protection of animals and the environment. I'll start with our End the Cage Age, which is a big campaign, which was launched in 2018, if I'm not mistaken, and has just seen some very, very promising developments. In June, the European Commission committed to drafting a legislative proposal by 2023 to gradually ban cages for a number of farm animals starting from 2027. And this is part of the ongoing revision of the animal welfare legislation under the EU's Farm to Fork strategy, which is one of the, let's call it, flagship strategies of the European Union right now. And this positive development, as I said, came in response to a European citizens initiative called End the Cage Age, which gathered, thanks to the collaboration of over 170 animal protection groups, over 1 million signatures from European citizens. And I think what might be interesting to know is what is a European citizens initiative, how it works, and what is the possible relevance of this positive outcome. So an ECI is actually a mechanism of direct democracy, which enables EU citizens to participate directly in the development of EU policies by inviting the European Commission to submit any appropriate proposal on matters where citizens of the European Union consider that a legal act is required. So it is a mechanism that can drive the change from the bottom, from citizens. And this is why it's so it's been so incredibly satisfying to be part of this initiative and to see how NGOs, groups working together were actually able to collect more than 1 million signatures to bring this forward and to actually obtain a positive response from the Commission. So who can launch an ECI? Basically, what you need is a group of organizers composed by at least 7 European citizens living in 7 different European countries. The objective here is obviously to represent all of the Union or more countries of the Union, so not just one or a few. European citizens that are old enough to vote in European elections can support it, or they need to be aged at least 16 in some of the countries. And to support it, there are obviously different rules for different countries. Some countries just require, your ID. Other countries will be more strict, requiring also a copy of your passport. But in any case, what I want to say, this is not just a regular petition where you put in your name and your email address. These signatures need to be verified. They need to be verified by the authorities of the different member states. So, as I said, you need to have at least 1 million signatures, and there are also minimum numbers laid out for the different European countries. So there needs to be the minimum number of signatures collected in at least 7 European countries, and this within 12 months from the kickoff date. What happens next? If you're successful in collecting the signatures and they have been verified, then within a month from the validation of the signatures, there's a meeting with representatives of the European Commission to explain the issue raised a bit more in detail. Within 3 months, the initiative will be presented in a public hearing at the European Parliament. And the Parliament may also decide to hold a debate in a plenary session, which could lead to the adoption of a resolution on the related issue. And then finally, within 6 months, the Commission must give a reply. It will spell out what action it will propose in response, if any, and what are the reasons. And this response is in the form of a communication that is formally adopted by the commissioners. And I do encourage you to read it. It's interesting. I've selected some parts of it in a later slide because it is definitely interesting to read what the reply is and in what direction European policymakers are deciding to take. So if the Commission considers legislation an appropriate response, it will start preparing a formal proposal. And once this proposal is adopted by the Commission, it will be submitted to the European Parliament and to the European Council, who need to adopt it to become law. And but just bear in mind that the Commission is not obliged to propose legislation. It might also propose other kind of measures. But in our case, in the case of this campaign, of this ECI, the reply of the Commission concluded as follows. First of all, that the initiative reflected some societal concerns that were supported by scientific evidence, that the Commission intends to put forward a legislative proposal prohibiting the use of cages for all the animals that were included in the initiative, and the list is pretty long. I've underlined them here for you. So that's quite a large number of species and animals. Under conditions that still need to be determined, including obviously the transition period away from cages, and these will be based on opinions from the European Food Safety Authority, on an impact assessment, and then public consultation. And one more very interesting element is that since the European Union is a major importer of food products, it bears a societal responsibility also with regard to the products it imports. And so the Commission will consider introducing rules or standards for imported products that are equivalent to the EU's, and or labeling requirement aligned with WTO rules. So potentially the EU might also require cage-free products from the countries it imports food from. So that is a very interesting development as well. So why is this relevant? What is the potential for legislation to ban cages in the European Union? Well, first of all, the European Union is in itself a source of law. So EU law has direct or indirect effect on the laws of its member states, and it becomes part of the legal system of each member state, meaning that what is adopted at EU level is then adopted in the countries as well. So what we are able to change with the EU institutions will then have an effect on 27 countries and on the animals being raised and living in these 27 countries. There is also something called the precedence principle, meaning that European law is superior to the national laws of the member states, and this applies to all European acts with a binding force. Therefore, member states may not apply a national rule which contradicts the European law. So if a ban on cage keeping were to come in effect at European level, the countries could not have regulations that say otherwise. And then this principle guarantees the superiority of European law over national laws. It is a fundamental principle. It's not inscribed in the treaties, but it has been enshrined by the Court of Justice of the European Union. All right, then I'll move on to next development, which comes from Italy, which is the country I'm based in. This is a development that HSI has also been partially involved in. So I have a bit more to say on this, trying to bear in mind that we have limited time. So Italy, the Italian constitution as it is right now came into force in 1948 and does not identify animals as recipients of protection, nor the environment, as a matter of fact. But what I want to say is that additionally to this constitutional shortcoming, there's also a strong anachronism of the civil code that continues to refer to animals as things. So a series of bills have been under consideration by the Constitutional Affairs Commission of our Senate, which finally in May found a political agreement, paving the way for the adoption of an amendment. And actually, in the past few weeks, there have been some developments, and our lower house has voted in favor of this amendment. The current text, as it stands right now, is not the ideal text. It is a compromise between all the political forces at play here, and it could still be subject to changes because the process for the adoption of a constitutional amendment is quite a complex one. It requires 2 votes from both of our chambers, and the second vote must have absolute majority. So yeah, actually this is the article referring to that. So the proposed amendment right now is the one that is here. There were earlier proposals that were stronger, in my opinion. There was one stating that the Constitution protects the environment and ecosystems, also in the interest of future generations. It protects biodiversity and animals. All others also provided for the recognition of animals as sentient beings. And later we'll see briefly why this is relevant, with an additional commitment to promote and ensure an existence compatible with the ethological characteristics of animals. But nevertheless, let's be positive, because an amendment to the Italian Constitution to explicitly include animals, finally elevating their status to another level and promoting progressive values, might soon be a reality. So I would like to further expand on why this is necessary. I believe the question here should be answered affirmatively. It is necessary to grant animals constitutional protection, and I think for two legal reasons. Firstly, out of the need to bring coherence and certainty to our domestic legal system, and also to align with European sources and with the developments in other European countries. So the introduction of amendments to the text of the Constitution may in fact contribute, in my opinion, to achieving some important developments, which very much align with the reasons as to why these are necessary. First of all, again, bringing greater consistency to domestic law. This applies both to the constitutional recognition of the environment and to the specific mention of animals and their protection in the Constitution, although I will focus more on the animal aspect in this presentation. Then secondly, making the Italian legal system, starting precisely from the fundamental principles of our country, coherent with the supranational EU legal framework and in line with the developments in other countries of Europe. And then basically translating into primary legal rule the societal need to pay greater attention and regard to the environment and to animals and to their respective protection. I think just really briefly, this last point is linked a bit more closely to political choices. However, the law is an instrument that binds citizens to the community and to the institutions. And this is where I think the legal and the political spheres need to interact. So in this sense, too, the amendment to the Constitution would meet the need for it to become the locus of the values shared by society. And what better locus, if not the first part of the Italian Constitution that focuses precisely on fundamental principles. All right, then, firstly, I'd like to expand a bit on the need for a constitutional provision to bring coherence to domestic law. In this very moment, our Italian Constitution does not protect animals, but also, if we look at our own legal system, calls for reform appear to be more than justified. The domestic legal framework reveals macroscopic biases, and these stem on the one hand from the difficulty of the current civil law taxonomy to fit coherently into the domestic legal structure, and on the other from the absence of a clear reference in the Constitution to animals. And I have a couple of examples. Firstly, the first example of conflict is the presence of Italian regional laws that identify the animal as sentient, and the duty to guarantee its welfare, although, as is often the case, only for certain categories of animals. And the conflict here lies within the fact that the reference to welfare and therefore to equality of life is not compatible with the classification of animals as a thing according to the civil code. There are also numerous animal protection provisions that are difficult to reconcile with the idea of the animal as a mere object of rights and not a subject. For example, there is a legal obligation to rescue animals injured by traffic independently from the location and existence of a possible owner as a potential damaged party. So what would be the purpose of such an obligation if not to protect another subject, which in this case is the animal? In addition to this, there is a wide set of criminal laws that punish criminal acts against animals, which generates a regulatory patchwork in which even the specialist doctrine is often disoriented when identifying the position of the animal as the object, or rather as a damaged subject, victim of the crime. Furthermore, we must also consider how jurisprudence increasingly refers to animal subjectivity and to the effects of such subjectivity in the judgment of disputes, such as the custody of pets when family members separate, or compensation for non-material damage, or in the event of the loss of a pet. And also reasoning in terms of legal remedy, even if we share the idea that in many cases we are faced with false positives of animal subjectivity, we could realize that the solutions and the compensation schemes used right now are incompatible with the notion of the animal as a legal thing, and perhaps prelude to the recognition of a right in terms of, let's think, for example, duty to render aid versus right to be aided, or duty of the owner to ensure the animal's welfare versus the right of the animal to have its welfare ensured. It would be precisely the superordinate constitutional dimension, the one to represent a clear and unmistakable reference point for legislators at both national and regional level, and for resolving in civil, criminal, and possibly administrative law the question and issues arising from the classification and consideration of animals. Second point, the need for a constitutional provision to align Italian law to the European framework, and this will apply also to the third topic, the one referring to Spain later on. Here it's necessary to mention Article 13 of the Treaty of Lisbon, which is relevant in terms of public policy, since it belongs to the primary rules deriving from EU membership. This treaty amended two treaties that form the constitutional basis for the European Union. This means that its text is already fully valid and binding in Italy and all other member states of the EU, while giving them the possibility to adopt more stringent rules, provided that they are compatible with what is in the treaty, of course. So in short, at least Article 13 of the Treaty of Lisbon, at least in this article, the quality or nature of animals as sentient has been recognized, and this text has supported a series of additional European provisions for the protection of animal welfare. So the supranational legislation, so that this treaty and other provisions represent a precise set of rules that Italy and other member states must comply with and adapt to apply in their respective legal systems. So again, a constitutional provision would just fall in line with what Italy, in any case, already needs to follow or bear in mind when drafting its own policies. So one would ask, if given Article 13, given it's already binding and valid in Italy and all member states, isn't it superfluous to mention the protection of animals once again in the Constitution? And I think the answer to this should be no. No, because it would tackle on the technical legal level a series of difficulties that are often insurmountable for ordinary legislators and for our jurisprudence, which, when faced with the question around animals, must deal with the rule of the EU treaty, which, yes, on the one hand offers the concept of animals as sentient, but does not necessarily translate into a rule that can be referred to resolve internal conflicts. So it can act as the missing link between EU and domestic law. And in this, I think that it is also necessary to recognize the general tendency towards the so-called constitutionalism of animal protection. In some legal systems, in fact, importance is given to the individual animal. And this is the case, for example, in Germany or Austria. And the sentience of this individual animal, to which the state must guarantee protection in a manner that is independent from it being part of the environment. And this tendency is increasingly complemented by another process, which is the one of dereification, or removing animals from the category of legal things, by which, in fact, civil codes are modified. So to conclude on this topic regarding Italy, I think this provision is very much necessary, first of all, to give coherence to domestic law, inserting animals in the Constitution. It can be a fundamental help by providing a basis for future legislation, a fundamental reference for legislators and jurisprudence, as well as being this missing link between domestic and European sources. And finally, I would add that the cultural weight of the Constitution cannot be overlooked. It is a law and a charter dear to citizens, which find societal reference in it, for the promotion of values. So I would say we've worked on it, we've pushed for it as HSI in Italy. So I think the time for this reform has certainly come. And I hope that we'll have positive developments in the months to come. The last update, the last development I'd like to share with you is coming from Spain. So in October, the Justice Commission of the Congress has approved a bill to amend the legal status of animals, enshrining their sentience in the Civil Code. And additionally, the bill will also amend Spain's mortgage law and civil procedure law in ways that are consistent with the recognition that animals are different from other forms of property. So this approval is just the first step. There's obviously a longer process ahead, but Spanish advocates and campaigners that have been pushing for this reform are optimistic, given that there has been overwhelming support by the different political forces, except for one. But luckily, they are not the deal breaker. Interestingly, as explained in the text of the bill, Spain had updated its penal code in 2003 to differentiate damage to companion animals from damage to objects. And with this reform that was further developed in 2015. And however, the government back then failed to likewise amend the civil code. This was supposed to happen in 2017, but then the bill was never finalized because the parliament was dissolved in 2019. And so now a new bill needed to be introduced. And this is the one. What is this reform about? Spain's proposed reform would change animals' legal status from things to living beings endowed with sentience. And as is currently the case with other legal systems that formally recognize animal sentience, animals would still be classified as property. However, it would essentially create a third category, something like living property, which differentiates non-human animals from human beings, but also acknowledges the fundamental difference between animals and other types of property. And the bill clearly divides the two concepts in a section that I've included here with the title, The Classification of Animals and Property, noting that when the concept of property is applied to animals, then their nature, well-being, and sentience must be taken into account. And interestingly, the bill notes also that while earlier versions of sentience legislation in Europe define animals by what they are not, so they are not things, kind of creating this category of non-things for animals. More recent versions, including Spain's proposal, define them by what they are. So in this case, sentient beings. So back to the question here, is it necessary and why? And yes, for two reasons that are actually included in the bill. The bill already explains why it's being brought forward. While the efforts for the reification of animals and the codification of their sentience are and have been at the center of debates about their practical effects, Spain bills makes clear that sentience must be a guiding legal principle for law and policy regarding animals in the country, and that, in other words, the reform is not supposed to be merely symbolic. They really wanted to affect the entire legal system for now and in future. The bill also frames the proposed reform by noting that it would align Spain's civil code with other European legal systems like Austria, Germany, Belgium, and more recently France and Portugal, along with the European Union recognizing animal sentience in Article 13 that we just mentioned. And thirdly, the bill states that the proposed reform would bring Spain's civil code in line with contemporary thinking of animals, that it would translate into societal norms and court decisions the need to pay greater attention to animals as sentient beings and not as objects. And even if it can be debated that such reforms have merely symbolic effect, they can have a positive impact. They can provide courts with legislative statements that can support the decisions favorable to animals' well-being and interests. And while the fact that animals are different from inanimate property, while this seems, I think, obvious to all of us, it is frequently a point of confusion in the legal system. And when courts are confronted with cases involving animals, the property designation without further clarification often leads to unjust outcomes that are inconsistent with the nature of animals as sentient, as living, feeling beings. So this reform can contribute to greater clarity by, for example, paving the way for judges to declare joint custody of pets in divorce hearings, just as they do with children, setting out criteria on which the courts must rely in deciding who to entrust custody of an animal, taking into account its well-being, or by giving owners the right to compensation for moral damage if their animal is hurt by another person. So I'm not going to repeat this, but again, this reform would be in alignment with the supranational framework of the European Union. And I think I'm doing really well with time, yes. And in conclusion, I'm asking this question again: isn't it superfluous to codify the legal recognition of animal sentience given Article 13 of the Treaty of Lisbon? And the answer here is no. Sentience laws can be viewed as laying the foundational groundwork for future reform. And similarly, it can be argued that sentience should be considered a basic principle, and that while not an endpoint, it can function as a baseline. And with that, I am concluding my presentation, and I thank you all, grazie, for your attention. And if you have any questions, I'll be very happy to answer.
Great. Thanks so much, Martina. That was wonderful. I really enjoyed listening to the presentation. I can see we have some questions in the chat, including from Tony. Tony, would you like to ask your question directly to Martina?
Yeah, sure. Thanks. So Martina, at the beginning in the discussion about your cage age initiative, you mentioned about the possibility that the standards set in the EU might be applied to importing countries as well. We're very excited about that because in South Africa, for example, our new animal welfare bill is already talking about animal welfare equivalency as a trade imperative. And so I saw some talk about the EU enforcing this with the Ukraine, for example. I'm wondering, do you think this is a realistic expectation that you would get both the European ban on caging and a commitment to enforcing these sort of standards with trade partners? Because that would be a huge multiplier, pushing those standards out throughout the world.
So, I mean, I think this is a very difficult question to answer. I think the intention is certainly there for one reason. So we have to bear in mind that the European Union was born as an economic union. What keeps us together is the single market. And one of the reasons why this reform needed to come from the bottom is because of the differences that there were between countries of the European Union. There are already some countries which had implemented cage-free or cage keeping bans. But the difficulty was to avoid products coming from cage keeping into the country. So I say Austria was a good example. They were not producing, they did not have cage keeping systems anymore, but still there was no possibility to control specifically for processed goods whether there were caged eggs or not in there, because other countries like, say, Poland, Hungary, Italy, Spain were still producing with cage systems. So in the sense of maintaining this economic interest of a union, I think what the European Union wants to avoid is to implementing this ban and therefore having higher welfare, which can lead also to higher production costs, and then having a huge variety of products coming from other countries that have very low standards and then can be more competitive in terms of cost. So I think the interest is definitely there. Whether it can be achieved right now, I'm not sure. There is the Commission wants to do this impact assessment, and I think part of that impact assessment will be precisely this, trying to understand what could be the timeline for a phase out in order to avoid really cheap caged products to come into the union, and to give also import-export partners the time to sort of adjust and get up to speed with us.
Yeah, great, thanks. Well, our minister responsible for our new Animal Welfare Act has said that the consultation process on that act should be finished by the middle of next year. So I'll leave it in your capable hands to get those standards into law by then, so that we can have them in our trade agreement as well.
Martina, I also wanted to ask a question about the cage side of things. And I'm not sure if you're familiar with this, but where in Australia, we're also trying to finally phase out the use of battery cages for hens. And it's amazing, but we still haven't got a commitment from our government to actually do that, although we're hoping it might happen by the end of this year. One thing that's been part of the discussion is whether they'll allow producers to move to furnished cages, or to basically like sort of
enriched cages.
Yeah, enriched cages, that's the other word. Yeah. How does that factor into the phase out? Are they still going to be allowed under the sort of the phase out of the cages?
Yes. So when we talk about cage keeping, we're talking about enriched cages. So so the next thing is basically barn keeping. So yeah. So yes, cages means the old systems, and enriched cages. So it's just going to be barn keeping and free range and organic. That's what's going to be left for us in Europe after that. And also, yes, so and that's so the ban is also not just for hens, but also for another series of animals like sows and other kinds of poultry as well.
Yeah, I saw that. It was a much longer list than I realized, including, you know, ducks and
veals and cows and veal crates.
It's amazing that the list is so long. Were there any sort of animals that were harder than others to get included on that list, or was that just sort of what was included in the petition from the beginning? That was included from the very beginning. Me personally, I was personally surprised that the Commission decided to move ahead with all of them. But again, I think that maybe the impact assessment will reserve us some surprises. Well, I hope not. I hope only positive surprises and not negative ones. But we'll see. I mean, for sure, there has been a lot of, you know, resistance from interest groups, from agricultural business groups, interest groups, sorry. But we'll see. I mean, the statements from the Commission, from the Parliament, because we had obviously the hearing at the European Parliament as well, have been really positive and really promising. But yes, we're trying not to get too excited and see what happens. No, I think it's amazing. I mean, sometimes I think we struggle so much in Australia as a pretty small country with a small number of states to get industry and governments over the lines on this thing. So the idea of doing it on the European level was pretty amazing that you've managed to get this far.
Are you importing a lot? Sorry, I'm asking the question. Is Australia importing a lot from, say, like Asia or Southeast Asia in terms of eggs?
We do import some, but I think our market is mainly domestic. So we actually have a lot of producers within Australia, and particularly in my state, New South Wales, which is the biggest egg producer. So the conversation's more focused around the domestic market and how that operates, as opposed to issues of imports and exports at the moment anyway. All right, well, look, thank you so much, Martina, for that presentation. I might get you to just stop sharing your screen if that's okay.
I don't know how to, I cannot actually do it. Somebody needs to start sharing something new.
Okay.
Oh, wait.
Well, why don't we leave that there?
Oh, no,
and leave
no, sorry, I got it.
Oh, you got it?
Apologies. Yes.
No worries. And I just wanted to say before we launch into our next speaker that I think I said to people to put their questions in the chat. There's also a Q&A function down the bottom where you can put questions too. We'll monitor both of them. So wherever you want to put your questions, that's fine. All right, well, we're going to move on to our second speaker today, which is Rui Lopes. Rui is the Managing Director and Head of African Relations of Lopes Attorneys, Inc. Lopes Attorney is regarded as a leading law firm on the African continent, having been shortlisted as a finalist at the African Legal Awards in 2021. Rui represents various animal welfare organisations, both local and international, and has represented them in relation to numerous work streams on enforcing and maintaining animal welfare standards in South Africa. And Rui is going to be talking to us today about ending captive lion breeding in South Africa. So I'll hand over to you, Rui.
Thanks, Tess. I'm going to share my screen. Can everybody see my screen? Yep. Okay, great. So firstly, thank you for that amazing introduction, Tess. And yeah, good evening and good morning to everybody, depending on the time zone that you're in. So going straight into it, what we're going to be discussing today, and apologies if this is something that everybody already knows, but I'll keep it short and simple. We're going to firstly be discussing the current legal nature of animals in South Africa. We're then going to be moving into an overview of Section 24 of the Constitution and the role that it plays in society in South Africa. We're then going to be considering the draft policy position, because ultimately that's one of the main documents in which Minister Barbara Creecy has sought to outlaw or ban, can we say that, the captive lion breeding industry. Then we're going to be discussing the impediments to the implementation and effectiveness of the draft policy position and the way forward in conclusion, and then have some questions and answers right at the end. So getting straight into the swing of things, for those of you who don't know, the current legal nature of animals in South Africa, this is a concept that for the most part has been inherited from Roman Dutch law, and South Africa's legal framework treats animals as property. Now, the issue that this brings along with it is that this often limits the protection that's afforded to animals, and it brings with it the concept or the rights that accrue to ownership being real rights in relation to animals. Overall, there's little to no formal recognition of animal sentience in legislation. The overarching piece of animal protection legislation in South Africa is the Animal Protection Act. Although it does go to some lengths to recognize animal sentience, and it acknowledges that animals as defined are capable of experiencing physical pain and criminalizing certain acts and conduct that's perpetrated against animals, there are a number of issues that come with the provisions of the Animals Protection Act. It is an outdated and antiquated piece of legislation, and it is criminal in nature. It's a criminal statute. So for the most part, for those who are on the call who know, there are obviously inherent issues around the South African Police Service and the National Prosecuting Authority. So, you know, what we are seeing is that there are low amounts of successful prosecutions and convictions due to these issues that are prevalent within them. So moving a bit forward into that, in 2008, the minority of the Supreme Court of Appeal, which was penned by Justice Emeritus Edmund Cameron in the National Council of Societies for the Prevention of Cruelty to Animals versus Openshaw, this was quite an amazing judgment or minority decision at that stage when Justice Cameron was on the Supreme Court of Appeal. That is something that I like to call the mindset shift. What this stated is that the statute, the APA, recognizes that animals are sentient beings and are in fact capable of suffering and of experiencing pain. And they recognize that unfortunately humans are actually capable of inflicting this suffering and then causing them pain. So the statute thus acknowledges the need for animals to be protected from human ill treatment. Although this was a minority decision, it was then referred to with approval by South Africa's apex or highest court, which is the Constitutional Court, in 2016 for the decision of the NSPCA versus the Minister of Justice and Constitutional Development. And thus our courts have started to expressly recognize the need to shift from treating animals as property to regarding them and treating them as sentient beings that are capable of experiencing pain and suffering. Although these two decisions are groundbreaking in their own right, and they do represent this mind shift change, or this mindset shift, the reality is that the change that's had to occur, especially from a legislative and policy perspective, has been done at a very slow rate. Recently, however, there have been a number of draft policy positions and guidelines and regulations that have been published for public comment, which when you look into them, they do go to some length and in recognizing and giving effect to animal sentience. Two of them that I've highlighted, although these are not exhaustive lists, are the draft policy position on the conservation and ecologically sustainable use of elephant, lion, leopard, and rhino, which is what we're going to be discussing today, and the draft guidelines for the exploitation of live animals by sea. This is not to say that they are perfect. This is not to say that they are sound in their own right, and then I think that that's a discussion for another day, but they do go to some length to expressly recognize animal sentience. That being said, a lot of these positions that have gone to some length to further increment the mindset shift are still in their draft form. And for a large portion, and as Tony alluded to before kicking off, these are still going to take a huge amount of time prior to actually being enacted and being implemented. So if we then look into section 24 and where that fits into the greater scheme of things and what its role is in society, it's important to understand that, such as in other jurisdictions, South Africa's constitution, including its Bill of Rights, is regarded as the supreme law of South Africa, and all law and conduct is required to actually give effect to and be done in accordance with its provisions, failing which it's regarded as being invalid and lawful and may stand to be set aside. That being said, however, South Africa's Bill of Rights does not expressly or explicitly provide for animal rights, unlike in other jurisdictions around the world, but South Africa's Bill of Rights does recognize environmental rights, which are contained in section 24 of the Constitution. Okay, and we'll get to how this fits into the greater scheme of things now. Section 24, importantly, is not a progressive right. There have been instances where the government, through practice at this stage, what we're picking up on is that the government is wanting to interpret the provisions of section 24 as a progressive right, similarly to the right to housing within the state's resources. This is an incorrect interpretation of section 24. Section 24 is not a progressive right and it accrues immediately. Okay, it also binds and is applicable to key role players, which includes corporates and the like, and they are required to be cognizant and give effect to its provisions. So quickly going into it, I don't want to take up too much time on this, but section 24A states that everyone has the right to an environment that is not harmful to their health or well-being. But importantly, when we look into the provisions of section 24B, this provides that everyone has the right to have the environment protected for the benefit of present and future generations through reasonable legislative and other measures that, and this is the important point, number one, that they prevent pollution and ecological degradation. Two, that promote conservation. And that is one of the operative words there, and secure ecologically sustainable development and use of natural resources while promoting justifiable economic and social development. Accordingly, section 24 encompasses not only the environment as a lot of people understand it, such as the biosphere and the like, but also the natural resources within it, which would naturally include the animals within that environment. The use of animals in any respect must be done in a manner that gives effect to section 24 of the Constitution. To this end, it's submitted that sustainability and conservation are required to be placed ahead of profits as a trade or an act which derives an economic or social development angle, but which is unsustainable in nature, nor which aims to secure conservation, would not be regarded as providing justifiable economic and social development. So let's look at a case study, and this is the point or the main topic of discussion. In terms of the captive lion breeding industry, the minister in her high-level panel report for submission, which was dated the 15th of December 2020, she actually goes to some length and expressly acknowledges that at the end of the day, the captive lion breeding industry does not provide any sort of conservation value to it. Any profits that are derived are not in the sense of what the minister would have expected, especially from a transformation perspective in South Africa's, unfortunately, socio-economically unjust society. And the report acknowledges that as it pertains to the captive lion breeding industry, that the slaughter practices for bone and products from lions are currently unregulated. There is also no differentiation between slaughter and euthanasia. There's unregulated and intensive breedings of lions that can result in long-term and short-term welfare concerns, and intensive breeding, crossbreeding, and backbreeding can result in congenital issues and contribute to lifelong welfare challenges. So the consideration that therefore comes into question is whether the captive lion breeding and the captive line breeding industry and the trade are actually justifiable under Section 24. And in my submission is that the short answer to this is no. The report contains 2 opinions that are prepared by a team of advocates, including senior counsel, and they deal with a number of legal aspects that have been engaged by the council and around the captive line breeding industry and the trade. These legal opinions are sound in nature, and they state expressly that Section 24b(3) of the Constitution poses a huge difficulty to the high-level panel, as it contemplates 2 objectives, namely the protection of the environment from pollution, degradation, and harm, and socioeconomic development. These are the 2 and 3 factors that we were talking about. Also, the Constitutional Court has expressly recognized in the Fuel Retailers Association decision that these 2 objectives need to be balanced through the ideal of sustainable development. Accordingly, the development must be compatible with the need to protect and improve the environment for the benefit of the population, meeting the needs of the present, without compromising the ability of future generations to meet their own needs. So the key take-home points from these opinions are: Section 24 of the Constitution undoubtedly contemplates animal welfare. And if they, the regulatory measures, policies, and practices, fail to secure ecologically sustainable development of natural resources while simultaneously promoting justifiable economic and social development, they do not comply with Section 24b(3). Moreover, the report acknowledges that the captive line breeding industry and trade fails to provide any conservation value for the most part. For this reason, the trade cannot be seen to give effect to Section 24 of the Constitution. So this is one of the main factors, at least it's submitted from my perspective, that has prompted the minister's view of ending the captive line breeding industry. Another consideration, and something that we will turn to, is as animals are still for the most part recognized as properties with changes with changes obviously being extremely slow. The next consideration becomes the provisions of Section 25 of the Constitution, which deal with the right to property. Section 25 has a specific provision within it that permits the expropriation of property, and we'll turn to this and we'll see where this comes in full circle, which would include animals by the state where it is through a law of general application, which the draft policy, and once it's enacted, will not be. It's in the public interest or for a public purpose. So in this instance, it will be for a public interest. And on the payment of compensation. This is an important point. Although there are amendments that are trying to be put in place to eradicate the payment of compensation as a prerequisite to expropriation under Section 25, that's still not yet implemented. So the question becomes what occurs in relation to the payment of compensation. So now, the draft policy position. This sets out the department's position as it pertains to, amongst other things, the captive line breeding industry. And for the purposes of this presentation, we are limiting it strictly to the captive line breeding industry. It was originally published for public comment on the 27th of June, with comments being open until the 27th of July, but thereafter it was extended until the 14th of October. So the draft policy position seeks to establish a number of policy interventions that will be taken by the department in relation to inter alia, the captive line breeding industry. And these include, but are not limited to, immediately placing a halt on the domestication and exploitation of lion and closing of captive line breeding facilities, preventing the live exports of South Africa's iconic species, and the adoption of the one welfare approach. So the draft position will naturally affect the trophy hunting industry as well. And that specifically is noted in the draft policy position as saying that trophy hunting is under increasing scrutiny and all activities related to it. The halting of the captive lion industry brings with it a proposed moratorium on the issuing of any further licenses and or permits in relation to the industry. However, this is yet to be put in place. So when we dig down into an analysis of the draft policy position, this expressly acknowledges that captive bred lions have a different genetic composition to those of wild lions, and that poses a significant issue on how these captive bred lions are going to be reintroduced into the wild, and that it is not capable of being done. As such, the draft policy identifies that the only appropriate mechanism to combat this is a mass euthanasia of captive bred lions. Moreover, the draft policy acknowledges that the captive lion breeding industry negatively affects the country's conservation reputation and does not bode well for the country's international standing and development objectives. It furthermore provides, and as was something that we've indicated before, that it does not provide any conservation value, and sustainable development or transformation is not being met through this industry. But importantly, a large portion of the draft policy refers to the impacts that are sustained by Brand South Africa through this industry, which we'll turn to shortly. Moreover, The draft policy position also notes that the draft National Environmental Biodiversity Act amendment provides for a definition of well-being, which will apply to inter alia lines. Again, and as Tony had indicated, these are drafts, these are bills at this stage, and they still require a huge amount of time before they are actually enacted and implemented. Overall, the policies mentioned in the draft policy are viewed as ambitious and requiring much effort and strategic implementation by the department and key role players in order for such to be effectively implemented. Okay, as it will be turned to now, it's submitted that there are numerous hurdles that remain prevalent to a successful and effective implementation of the draft policy. So let's look at some of the impediments. So concern number one, and this has already been identified by a large amount of individuals in the industry, there has been way too much emphasis on brand South Africa in the draft policy position. So the draft policy indicates that the harm that the trade brings to brand South Africa. But this is a relatively difficult position or viewpoint that has been adopted by the minister, especially when one considers that the trade is currently lawful. Moreover, South Africa as a country is not a business. So we cannot equate it to say that we as citizens or residents are its loyal servants and we must uphold and give effect to and make brand South Africa the best version of itself, similarly to how an employee must respect and promote the business. This raises doubts as to whether the draft policy will in fact actually be capable of surviving legal scrutiny. Additionally, there's the possibility that the harm that's caused by a mass euthanasia might actually be more damaging to brand South Africa. So concern number two, and this is something that is identified from the actual wording of the draft policy position, it itself notes that the last census that was undertaken on the number of captive line breeding facilities and the number of captive lines was only in 2019. This census noted that at that stage, there were 366 official captive line breeding facilities. Of these, 97 were captive hunting facilities and 10 were sanctuaries. Hunting trophies amounted to 8,855 that were exported between the period of 2008 and 2017, with 1,895 live exports of line having taken place during the same period. So accordingly, there's no updated census that has been conducted by the department. And what this poses, and the reason why this is an impediment, is that it would therefore be difficult to determine the exact extent to which the policy interventions, which include mass euthanasia, are to take place and the resources that are going to be required to undertake this and how it's going to be implemented in practice. Another major concern, and for me, this is one of the bigger concerns that needs to be fleshed out and actually discussed, is a concept of cooperative governance. Now, South Africa's constitution expressly recognizes this, and it expressly indicates that there are instances in which certain conduct is not conducted on a national level, but it's also conducted on a provincial level, and sometimes it's delegated to be on a provincial level, or it could be exclusively on a provincial level. These are concepts that we talk about in Schedules 4 and 5 of the Constitution, and it's the concept of exclusive and concurrent competence. So unfortunately, what has occurred is that, and this is a term that I like to call it, having dealt with this in practice, that unfortunately, the way that the government has interpreted cooperative governance is in a manner to say it's cooperative ignorance. And this is because it results in a passing of the buck situation, in that the national government won't deal with it, but it'll actually be the provincial government that deals with it. So a lot of the permitting and the licensing that takes place is not done on a national level, but rather done on a provincial level. The issue here is that the manner in which these activities are actually undertaken therefore differ from province to province after it's been delegated. And this is one of the reasons that may seek to explain why a large percentage of all captive line breeding facilities are congregated in the Northwest Free State and Mpumalanga, for example. Moreover, there's little to no communication that actually emanates from a provincial government level to a national government level, and vice versa. When one considers the policy interventions that we've discussed and what the minister seeks to implement, a large percentage of how effective the implementation of this is going to be is going to draw down, or is going to nail down on how effectively the cooperative governance framework can actually be implemented in South Africa. And that's, in my view, going to be extremely difficult. This, unfortunately, may result in an inadequate or complete lack of implementation of the draft policy, or the policy once it's enacted. So another issue, and one of the last concerns that we'll be discussing, is that the state is actually going to be dealing with a difficulty when it comes to Section 25 of the Constitution. When we consider it, as we've discussed, animals are still regarded in terms of the enabling legislation and in terms of the legislation, for the most part, as property. When you consider the task or the policy intervention of a mass euthanasia of captive bred lions, the question then becomes, is the state actually not expropriating your property because they are then getting rid of it? However, arguably, this would only be capable of being implemented where the state therefore takes ownership of that property, and they may only do this where this is performed in accordance with Section 25. Now, that's obviously up for debate. It's still speculative, but at least from what I can interpret from the draft policy position, that is one of the impediments that I can identify here. If this is not the case, it would be difficult for the state to argue that one is required to euthanize the lions under law. It would essentially be an election. In other words, do we euthanize or not? So from that perspective, a number of other questions come into play. In other words, if there is going to be payment of compensation to owners of captive bred lions, what are the resources that the state is going to expend in actually effectively implementing that in order to get that across the line? So what does this mean for us as attorneys, as animal welfareists and the like? The reality is that when it comes to the draft policy position, although we must commend Minister Barbara Creasy, these are great strides that have been taken. Number one, in relation to the recognition or the express recognition of animal sentience. And number two, in seeking to stop and bring a halt to an industry that is riddled with animal welfare concerns and that which provides little to no conservation value at all. There still remains a large amount of work that's required for the minister. So once she's completed the draft policy and implemented it and published it and it becomes the policy, that in itself does not alter the law automatically. There's a number of pieces of legislation that would require an overhaul and amendment, some of which are on the go. But again, there's still a large amount of work that's required there. From a draft policy position perspective, there's no clear indication as to when the final draft or the final policy will be published, but it's likely to occur during the course of next year. But that being said, one of the concepts that, or one of the points that we also need to expressly acknowledge is that once the policy position is published, it will likely be met with litigation in an attempt to review and have it set it aside, mainly from pro-trade organizations or bodies. Obviously, depending on how it goes, the reality is, and as we've discussed, there are certain impediments or hurdles that need to be expressly recognized and taken cognizance of, failing which there are strong merits in actually having it set aside in certain respects. Moreover, a policy in itself does not carry the same weight as law. Therefore, the minister will still be required to enact various pieces of new legislation and amend existing legislation to effectively implement the objectives sought in the policy. So obviously, with any piece of legislation that's either being drafted from scratch or that's being amended, this is an extremely protracted process, and that can take many years to complete. So I thank you. I'm pretty sure that there's questions.
Thanks so much, Rui. That was really interesting, particularly coming from Australia, where I'm not as familiar with what's been going on. So thank you so much for that. One question I had just right off the bat, if I can jump in, is about the mass euthanasia, which was obviously, pretty confronting to hear about. What is and sorry if you addressed it and I missed it, but what is the sort of the justification for requiring a mass euthanasia? Like, why wouldn't it be sort of a phase out situation where, stop any further breeding and let those lions live out their lives?
Sure. So Tess, from that perspective, it's an interesting one, and it's an interesting position that the minister's adopted there. So some of the reasons that she stated in the draft policy position is the genetic composition of those lions. So in other words, what she's in, if we take it from the beginning, what she wants to do is to put a halt on the issuing of any further permits or licenses. So no new captive bred lions will be permitted, no new facilities will be permitted to operate. In addition to that, what they've said is when we dig down into it, the genetic composition of captive bred lions are extremely different to those of lions that are in the wild. So from that perspective, they are practically saying, and this might be a difficult one, and that's the point that I've made in the slides, is that it might actually do more harm to brand South Africa than good, is they saying, well, it's better to then euthanize than to have them sitting in deplorable conditions, which are prevalent in captive lion breeding facilities across South Africa. And that's one of the main justifications that she's posed there. Again, when you dig down into it, it's kind of 6 of one and half a dozen of another, right? I mean, there's no clear indication as to whether that's actually going to be the final position that they're going to take. Moreover, it's unclear on how they're actually going to effectively implement it. And I know I've had countless discussions with Tony on this as well, is I don't foresee that the state in itself, as the department, is well resourced and well equipped to actually carry that task out in itself. It's going to have to rely on other organizations. It's going to have to actually reach out to, animal welfare organizations such as the NSPCA, for example, in order to be able to do that. Otherwise, they're not equipped to do it. But yes, to answer your question, Tess, it boils down to a situation of, when you're balancing up the two harms, do we do a mass euthanasia, or do we say it's fine, we won't permit more, but we will continue those captive lions that are currently alive to be in deplorable conditions, which is evident. I mean, just a couple of weeks ago, there was terrible news about a number of lions that were killed in the Free State that had to be put down due to a fire that occurred there on one of the facilities. So that is just one of the examples that one could provide on that front.
Thanks, Rui. Yeah, it's very sad options to continue. I think Tony had some questions he wanted to jump in with.
Sure.
Thanks, Tess. So Rui, back in 2016, I think there was a parliamentary colloquium on the question of captive lion breeding. It ran over 2 or 3 days. A large number of involved people entered into that process, and as a result, some resolutions from that process were adopted by the National Assembly, by Parliament, directing the minister to take certain steps to shut the industry. Does that not provide her, I mean, I think this is an interesting constitutional question. Here you've got the legislature making a direct, taking a direct position, instructing the executive branch to implement the will of the people, basically. Does that not give her a strong legal position that she might use to overcome or to counter some of the arguments that you've raised that will undoubtedly be put in as obstacles in her way?
Sure, Tony. I think that's a really, it's a really, really good question. I mean, at the end of the day, that's one of the main points that for a large percentage of people in South Africa looking at this, they're saying, but these parliamentary resolutions were passed in 2016. Why is it that we've had to wait 5 years for you to come out with a draft policy position on ending captive lion hunting and captive lion breeding? You knew for a fact that 5 years ago that this was an issue. That was what the parliamentary resolution stated as well. Strictly speaking, those are binding against the minister, and the minister can be racked over the coals for not actually implementing and giving effect to those parliamentary resolutions. One of the difficulties, Tony, is I stand under correction, but I don't think Minister Barbara Creasy was the Minister of Environmental Affairs at that stage. So she came in, I think, 2 years ago, Tony, 2019, 2020.
Yeah, end of 18, beginning of 19, I think.
Yeah. So what she's done in the time that she has been is actually quite progressive for, unfortunately, the reality of cabinet in South Africa. We're lucky that she hasn't been shuffled as most of our ministers. But the reality is what she's done in the 2 years there is actually been quite progressive in terms of an animal welfarist point. It might not be perfect, but it is progressive to a large extent. But to simply answer your question, Tony, she could use that as a justification, but I think it's a difficult argument to advance. And the reason why I think it's a difficult argument to advance is because of the lapsing of time that's occurred. The reality is her predecessor should have actually put the wheels in motion, if we can call it that, to actually get this across much sooner. Unfortunately, and this is the one frustration that I have as an attorney operating in this space, is a draft policy is great, but what it just tells us is what the department's stance on a specific point is. It's a policy intervention. How those are actually implemented in practice is the main point of concern as animal welfare groups, as attorneys who act on behalf of animal welfare groups, because those are the points in which we can get successful court orders or successful victories against. It's those standards or those thresholds which we can say, but you didn't do this or you did do that.
She could conceivably, or the Parliament could pass law, or the executive branch could pass regulation or conceivably they could do an administrative action such as say, okay, no future permits, which would sort of put the industry on notice, and then it would lead out the path that Tess has described, that the current animals could not be seized or otherwise those owners dispossessed, but she could, for example, continue the ban on export of lion bone, regulate canned hunting, basically squeeze the revenue streams out through administrative action, which would in effect lead to a closing of the industry, perhaps without the challenges to Section 25, the expropriation of property per se.
Sure, and I think so. So Tony, 2 points on that. I think the unfortunate reality is, especially when it comes to the captive lion breeding industry, we're dealing with a highly contested and highly problematic industry, and that's because of the revenue generation capabilities that it has for, not necessarily for the farm worker, but for the individual who actually owns the lion, right? So any administrative action that the minister is going to take, be it to not set a quota and stop all exportations or the like, any administrative decision is going to be reviewed. Now what happens is, as soon as she makes the administrative decision, it's reviewed. We've got 7, 8, 9, 10, 12 months waiting for a decision by the High Court, which is then, depending on the budget that those individuals have, might be appealed to the Supreme Court of Appeal, might make its way to the Constitutional Court. Whilst the reality is what's happening in the background is that from a welfarist perspective, those contraventions and those cruelty instances are still occurring. So, you know, from a minister's perspective, you know, and I give her credit. I mean, I must give her credit. It's a difficult position to be in because you're stuck between a rock and a hard place. Whatever she does will not necessarily fully support one position or another, but it's going to be, how do I say it? It's going to be like a tug of war between two opposing and completely polar opposite points, right? I mean, I think that that's the important thing to understand here is, at the end of the day, she's got a difficult argument to advance. I think as the current draft policy position stands, I'm concerned when I look at it, because there's too much emphasis on brand South Africa. That cannot be the minister's justification for taking a trade which currently under legislation is lawful to say, well, we're not going to do it anymore. We're going to make it unlawful, or we're going to make it ban. We're going to ban it. I think that there needed to be a sense of why Section 24B3 features into this, and that needed to be the predominant or the heavier argument. And she had the backing for that in those constitutional opinions. That's why I love those constitutional opinions, because they were so clear in what they provide and how the trade needs to be regulated and why the trade needs to be regulated. I think, Tony, on your other point on avoiding the Section 25 arguments, Joe has, hi Joe, but Joe has raised a really good point, and he says just a point to consider on why the banning of captive, sorry, my mouse here, Tess, I don't know if you can just jump in here, on why the banning of captive lion breeding and hunting is not expropriation. The government can be argued to be a custodian per NEMA principles of the lions, which are part of the environment. Your argument was similar to the finding in a famous mining case, Agri-SA, regarding transformative provisions in the MPRDA. I get that. The only difficulty and what we're seeing in the NEMA principles is that they are exactly that. They are principles. Not one is more superior than the other. They are just a set of guiding norms or points that should guide decisions that are made under NEMA, right? The problem becomes is, has this decision actually been made under NEMA, right? I know that the HLP for a large portion was established under NEMBA, but the question becomes is, the decisions that she's going to be making, are they derived under NEMA? If they are, then 100%, there's a really good argument that the pro-policy position could go and use. But I unfortunately see that the reality is, when we look at its substance over form, you're taking someone's animals, you want to euthanize them. I think that the reality is you're taking someone's property and you're depriving them of their real rights, that in terms of our current law and how we treat animals is going to be a difficult tussling of arguments that are going to be before a court.
Thanks so much, Rui. That was so interesting, and thank you so much for being with us today. If I could get you to stop sharing your screen, that's perfect. We'll jump straight into our next speaker, Bianka Atlas, who's going to talk to us about the use of farrowing crates in New Zealand and how lawyers have mounted a really successful challenge to the practice in New Zealand. So I'll start by introducing Bianka. Bianka is a lawyer from New Zealand. She has a master's in animal law with honours from Lewis and Clark Law School, where she was a Brooks Institute for Animal Rights Law and Policy International Scholar. Bianka received her Bachelor of Laws with honours and Bachelor of Arts from the University of Auckland and her Master of Science from the University of Edinburgh. Bianka has researched, published and presented on a range of animal law issues, including aquatic animal protection, international wildlife law, plant-based meat labelling, and the link between domestic violence and animal abuse. So I'll hand over to Bianka.
Thanks, Tess. Can you hear me okay?
Yeah, you sound great.
Can. Okay, awesome. Okay, just checking that you can see my presentation. Okay, great, thank you.
Thanks, Bianka.
Okay, good morning, good afternoon, good evening. Thank you to Tess and Tony for inviting me to speak today, and to the Centre for Animal Law Studies for supporting this webinar. It's a real pleasure to have this opportunity to engage with the global animal law community from around the world. So today I'm going to share a recent case law development in New Zealand, which is a significant victory for animals, for pigs in this instance, but with much broader significance. So in November 2020, the High Court ruled that the Minister of Agriculture and the National Animal Welfare Advisory Committee, which is an advisory body to the Minister, acted illegally when they failed to phase out the use of farrowing crates. So I'll just start with some brief background about pig farming in New Zealand. We have around 100 commercial pig farms. Around 800,000 pigs are raised and killed in New Zealand each year, around 60% of whom are raised indoors. And just to highlight some key differences between breeding sows and wild sows, on average, breeding sows are made to have around 2.4 litters per year, with up to 15 piglets per litter, and are slaughtered at around 4 years of age. In contrast, wild sows average around 3 to 5 piglets per litter and have a natural lifespan of up to 20 years. So I think it's just important to highlight that context of the intensive farming industry to start with. As for free range, only about 1% of pork farmed in New Zealand is free range, and there's only 2 commercial free range pork farms. These are much smaller than indoor farms. One of them in the Wairarapa has only 55 pigs on 20 hectares, compared with 60 pigs in just one shed at Southern Pork, one of the larger farms. And pigs on the free range farms are farmed entirely outdoors from birth to death. So what are farrowing crates? Well, these were at the centre of the High Court decision. They're small barred metal cages in which female pigs are put 5 days before giving birth, and they remain there until their piglets are weaned at around 4 weeks of age. And so you can see from the photo that the cages are only slightly larger than the pig's body. She has just enough room to stand and to lie down, but is unable to turn around. These crates involve severe physical and behavioural restrictions. So there's space on each side of the crate for the piglets, but there's no bedding or stimulation. So the mother pig is prevented from expressing natural behaviours such as nest building. And this leads to boredom and distress, which is often manifested in tail biting and other aggressive behaviours, which are then addressed by practices such as docking piglets' tails. And this can be done without pain relief on piglets under 7 days of age. So just interesting to note the differences in terminology used by different stakeholders. And I think this highlights the contentiousness of the use of this farming system, and perhaps an attempt by industry to sanitize or downplay the reality of what these farming systems actually entail for these animals. So there is a lot of debate over whether farrowing crates save lives. The sort of mainstream farming industry perspective, which uses the cage systems, refers to the crates as maternity wards, and they argue that they're necessary to protect piglets from being crushed. The free-range pig farmer perspective is a little different. So according to the owner of one of the 2 free-range farms that I mentioned, she said that they've mitigated piglet crushing without cages. She said, we have smaller litter sizes, with larger piglets, more robust piglets. We also have very maternal mothers. So a combination of those two factors contributes to less crushing problems. And she just doesn't believe cages are necessary. And she says, we're just not willing to compromise and have cells in crates. It's just not something that we believe is how they should be treated. We're already asking pigs to give us their lives. We're asking a huge amount. How can we possibly ask them to compromise more of their natural behaviors, the natural positive things that happen in their lives? So does the research support the mainstream industry view that these crates save lives? Well, research indicates that on average, 1 or 2 piglets are saved per litter compared to outdoor farms. And this was from Welch 2016, who reported a piglet pre-weaning mortality of just over 17% for outdoor farms and just under 12% for indoor farms. It seems that there's possibly no significant difference in mortality rates, but that the causes of mortality differ according to farming systems. So perhaps starvation and stillbirths are more common indoors, whereas crushing are a little more common outdoors. And so while it appears that crates may prevent some crushing, the inescapable fact is that crushing only arises because breeding practices in New Zealand and globally produce unnaturally large sows with unnaturally large litters who are kept in intensive confinement, all of which of course exacerbates the risk of crushing and other welfare issues. So this sort of sacrificing of the welfare of sows also in order to protect piglets has become standard practice really, but it's important to note that New Zealand's animal welfare legislation doesn't authorise any such trade-off between the welfare of the mother pig and the piglets. And according to some animal welfare experts, not only is there no welfare justification for sows, for crates, but crates also don't actually meet piglets' welfare at all. They prevent piglets interacting with their mother and confine them in such a small space where they're actually more likely to be savaged. And also just to note other well-documented safety issues, the key one of which with the farrowing crate system is that they're very prone to fire because of the heat pads used for piglets. And where there are fires in these intensive indoor systems, there's generally a total loss of life because there's no chance for the pigs, of course, to escape from their cages. And this has occurred in New Zealand and also in other countries such as in the Netherlands in 2016, when more than 10,000 pigs perished due to a fire, and also in Northern Ireland in 2020. So farrowing crates have been in the spotlight for some time in New Zealand, and they were the subject of one of the largest ever parliamentary petitions organised by the non-profit animal rights organisation SAFE. So this petition gathered 112,000 signatures and was delivered to Parliament in 2018, and it called on the government to ban farrowing crates. So turning now to this case, the applicants were the New Zealand Animal Law Association, or NZALA, which is a coalition of volunteer lawyers, of which I'm a member. It has the support of some very experienced practitioners, one of whom was lead counsel in this case, Gillian Coombe QC, she's a Queen's Counsel. And the other applicant was SAFE, Save Animals from Exploitation, as I mentioned, the animal rights organisation, where I was until recently one of the campaigns managers. The respondents in this case were the Minister of Agriculture and the National Animal Welfare Advisory Committee, or NAWAC. And this is a committee that it's one of 2 committees that has been established as an ostensibly independent body to advise the Minister of Agriculture, and NAWAC is entrusted with preparing detailed rules on the treatment of animals. The other body is the National Animal Ethics Committee, which advises the Minister on issues relating to the use of animals in research, testing and teaching. So the case was a judicial review of regulations 26 and 27 of the Animal Welfare Care and Procedures Regulations, which I'll just refer to as regulations, and minimum standards 10 and 11 of the 2018 Code of Welfare for Pigs. So regulations and codes of welfare are subordinate or secondary legislation which are issued under our primary legislation, which is the Animal Welfare Act 1999. Regulation 26 sets minimum requirements for the use of farrowing crates. It allowed for crates that are big enough for the pig to be able to stand and not touch one of the crate's sides. Regulation 27 prohibited confining pigs to sow stalls other than for mating and for no more than 7 days per reproductive cycle. The 2018 Code of Welfare allowed for the use of crates and stalls as a minimum standard of practice. So farrowing crates and sow stalls have always been considered to be non-compliant with the Animal Welfare Act, simply because they do not allow pigs to display normal patterns of behaviour, which is required under the Animal Welfare Act. However, the crates were historically permitted under an exceptional circumstances exemption, and this exemption allowed for practices that were inconsistent with the Primary Act's purposes. However, in 2015, Parliament signalled its intention to phase out non-compliant practices by repealing this exceptional circumstances exemption, and this was done through the Animal Welfare Amendment Act 2015. And Parliament enacted regulation making powers that prescribe timeframes for transitioning from non-compliant practices to practices that fully meet the obligations of the Act. So following decisions and recommendations of NAWAC, the Minister recommended 2 regulations, 26 and 27, and amendments to minimum standards in the Code of Welfare that did not require a transition timeframe. So in other words, this would allow the use of farrowing crates to continue indefinitely. So just a little more detail on how the regulations and the Code of Welfare being challenged came into existence. So the regulations were made under the new powers introduced by the 2015 Amendment Act, the act that I just mentioned. And they were made under section 183A. So 2 types of regulations were made possible by this section. Subsection 1 prescribes standards that either meet the welfare standards of the Act or establish minimum standards through welfare codes that ensure the purpose of the Act is met. On the other hand, subsection 2 prescribes temporary standards that are inconsistent with the purpose of the Act, but there's a phase out period. Basically, it specifies the period that they apply and it can't exceed 10 years. So the regulations in question in this case were made under subsection 1. So you can see that this meant they had to either meet the welfare standards of the Act or establish minimum standards through welfare codes that ensured the Act's purpose were met. And now the 2018 Code of Welfare. So animal welfare codes can be issued by the Minister under Part 5 of the Animal Welfare Act. And codes of welfare basically establish minimum standards that ensure the purpose of the Act is met. And the Act's purpose is embodied in the long title and also in section 9 for Part 1 of the Act, which deals with care of animals. And so this purpose includes to ensure that owners of animals and persons in charge of animals attend properly to the welfare of those animals. And codes can also prescribe standards of best practice. So the 2018 code in question here replaced the previous Code of Welfare, which was issued in 2010. Both these codes prescribed minimum standards for the use of farrowing crates and sow stalls. However, it was understood that the minimum standards in the earlier code were applicable to those exceptional circumstances, statutory exemption that I mentioned, and that at the time, just as a reminder, allowed for practices that were inconsistent with the Act's purposes. So the Minister issued the 2018 code without changing those minimum standards. And in this case, the court said that welfare codes must ensure the purpose of the Act, the purpose of the Act are met. So since the removal of the exceptional circumstances exception through the 2015 Act, welfare codes could no longer prescribe minimum standards that did not ensure the Act's purposes were met. So because the 2018 code prescription of minimum standards allowed farrowing crates, it did not ensure the purposes of the Act. So it's important to remember that Parliament delegates power to the government to make secondary legislation, such as regulations and codes of welfare. But the secondary legislation is always subordinate to primary legislation enacted by Parliament, such as the Animal Welfare Act. So this means when secondary legislation is inconsistent with the primary legislation, the court can strike it down as invalid and unlawful. And that's exactly what the court did in this case. It basically said that since the 2018 code and regulations allowed for farrowing crates without any indication of when they'd be phased out, they undermine Parliament's intention that non-compliant practices such as this would and should be phased out. Since it undermined Parliament's intention, it was ultra vires, or beyond the power given by Parliament to the government, and thus unlawful. So specifically about the 2018 code, since the minimum standards 10 and 11 of the 2018 code prescribe standards that didn't ensure the purpose of the Act was met, they were invalid. And the court held that restating the old minimum standards under the new Code of Welfare did not mean that the practices of using farrowing crates became compliant with the Act's animal welfare obligations. And with regards to the regulations, the court ruled that the regulations were invalid because they failed to meet either of the requirements under section 183 subsection 1. So the regulations prescribe standards that did not meet animal welfare standards under the Act by allowing for the practice of farrowing crates. The judge commented that the regulations allowing the use of farrowing crates could have been lawful if they were made under subsection 2. And just as a reminder, that was temporary standards that are inconsistent with the purpose of the Act, but there has to be a maximum time period, which is 10 years before they're phased out. So yeah, she commented that the regulations could have been lawful if they were made under that subsection. However, this would have required the minister and NAWAC to recognise that there were no practical alternatives to the practice. And as the subsection says, they would have to recommend a specific time period to allow the exception. So there's several reasons why circumstances arose for a successful judicial review, I believe. And a lot of these relate to major flaws in the animal welfare system. So in terms of NAWAC, it's really plagued by under-resourcing in general. NAWAC has repeatedly said itself that its work is limited by a lack of funding, generally has made quite slow progress on producing regulations, and has quite a limited work program each year due to this lack of just a lack of resources. It's also been argued that there's insufficient independence between the Ministry for Primary Industries and NAWAC. For example, the ministry provides the Secretariat. NAWAC appears not to have their own independent legal advisors. So, you know, it appears that NAWAC relies quite heavily on the ministry. And also there's industry pressure, which is not an issue that's unique to New Zealand. For example, New Zealand pork has a very powerful influence and arguably almost a stranglehold on regulators. Therefore, this makes it very difficult for there to be true accountability. With regards to MPI, it appears that animal welfare simply does not get the resources it deserves. So for example, in the 2018-2019 financial year, only 1.6% of the ministry's allocated annual budget was allocated to all aspects of animal welfare enforcement, education, and policy advice. So the ministry received 660 million New Zealand dollars, and of this, only 10.8 million was spent on animal welfare. And in 2018, only 26 cases of the over 1,000 complaints that the Ministry for Primary Industries received led to prosecution. So this represents only 2% of all complaints, which is much lower than in other areas of criminal law. And compared with the money made from the export of animal products, which came to around 28 billion New Zealand dollars in 2018, the Ministry for Primary Industries spends less than 0.02% of that figure on enforcing laws passed to protect animals. Another issue that's been well documented is that there are not enough inspectors, animal welfare inspectors, to cover the whole country. So we have almost 200 million farmed animals nationwide, but only 27 full-time dedicated animal welfare inspectors. That was at August 2020, and I don't believe that that figure has changed much since then. And this direct effect of under-resourcing is that the ministry lacks the capacity to engage in proactive enforcement and instead relies very much on reactive enforcement through public compliance monitoring, for example, complaints and reports of offending from members of the public and undercover investigations from animal rights organisations. And in some instances, industry self-regulation. And in November 2019, one of the worst known mass animal deaths in New Zealand history occurred. This was where 200,000 caged chickens died at a poultry farm after there was a power cut and a backup system failed. And MPI apparently was not aware of this catastrophe until they were notified by the media. MPI also has a conflict of interest. Basically, it's the industry that's the government department that's responsible for enforcing the Animal Welfare Act, but the primary function of the department is the promotion of New Zealand agriculture and exports. So MPI's role regulating animal welfare, well, it's not difficult to see how their role regulating animal welfare can become secondary to that primary concern. And again, this is an issue that's certainly not unique to New Zealand. So looking at specifically how these issues manifest in codes of welfare. So most codes of welfare are drafted by the very industries that use or produce the animals. For example, the pigs code of welfare was drafted by the New Zealand Pork Industry Board. The broiler chickens code of welfare was drafted by the Poultry Industry Association of New Zealand. So yes, NAWAC does consider and refines the drafts of these codes of welfare, but the initial version is obviously going to set the tone. So I think that's a real issue. Also, there's been criticisms leveled against the use and misuse of science by NAWAC, and that the use of science has sometimes been erratic or selective. For example, NAWAC has cited the lack of New Zealand research as a reason for declining to implement tougher animal welfare standards in the Pigs Code of Welfare and in other codes, despite the existence of a wealth of international scientific evidence about comparable intensive farming conditions. It's been argued, or MPI has claimed, the Ministry for Primary Industries has claimed that the strength of codes of welfare is educational value, and this will, that they improve community awareness of the needs of animals, and they drive and encourage the industry to improve practices over time. So they have this sort of incremental, this effect of incrementally improving welfare for animals. But there doesn't really seem to be any real evidence to suggest that offending has decreased since codes of welfare were developed. So I'm not quite sure if that claim really stacks up. And this does beg the question, and several animal advocates have asked this question, do codes of welfare actually enhance animal welfare, or do they just legalize or legitimize conduct and practices that would otherwise be illegal under the Animal Welfare Act? And thereby in doing this, they prevent any meaningful animal welfare improvements from being realized. Just to mention developments since the judgment was issued in November last year. So the government has agreed on a 5-year timeframe for the phase out of farrowing crates by 18th of December 2025. The Ministry for Primary Industries has also initiated consultation on the Code of Welfare for Pigs with a view to issuing a new code. And NAWAC has set up working groups and subcommittees in relation to other aspects of the Code of Welfare for Pigs that need to be addressed. So I would just urge animal lawyers, advocates in New Zealand to monitor these processes very carefully and to ensure that the government is held to account if they either fail to follow through or if there's any undue delay in the process. So what are the implications for the judgment? Well, farmers have said that retrofitting farms would be extremely costly. Prior to the decision, Southern pork owner Jason Palmer said that if change was to come, it would be devastating for our industry. It would wipe out more than probably half of the indoor systems in New Zealand. So it really remains to be seen what will happen over time with this, with the pig farming industry in New Zealand. For regulators, for the government and for NAWAC, well, it's fair to say that they're under scrutiny. The issue of the legality of secondary legislation, these codes of welfare and regulations, is now front and center, and it's also has a level of public awareness that it didn't have before. And also, I think it's important to note the importance for New Zealand's international reputation here. Around 50% of New Zealand's export earnings depend on animal exports, and the World Animal Protection Index in 2020 downgraded New Zealand from an A to a C. So I think it's just really important to be cognizant of how the international community is regarding New Zealand, and this is obviously very important for New Zealand's trade relationships with the rest of the world. For animal advocates, well, it's great news, obviously. It's the first time the Code of Welfare has been judicially reviewed in New Zealand, and it was a successful challenge. I think the decision is a good precedent. It's a pretty bold, strong judgment and opens the door to further challenges under the Animal Welfare Act. Given the court's finding that the regulations and minimum standards in the Code of Welfare were issued in error, I think it would be well worth looking at the legality of other codes of welfare and regulations already in existence, and those that are going to be introduced in the future, and to be ready to challenge these if required. The judgment also contains some other useful commentary. For example, it mentions Section 73 of the Animal Welfare Act, which relates to matters to be considered by NAWAC when considering draft codes and whether to recommend to the minister whether a code should be issued. So in the decision, Justice Cull said that considerations of practicality and economic feasibility are relevant, but secondary to animal welfare considerations. So I think that's really helpful to have that enshrined in the High Court judgment. And of course, the case has brought a lot of increased credibility and visibility for the applicants, for SAFE and the New Zealand Animal Law Association. And the industry will now see that these organisations have teeth to challenge the government and to win. I think, though, it's really important to maintain the momentum and just to make sure that advocates keep the pressure on government. So indeed, in July 2021, the same applicants, SAFE and the New Zealand Animal Law Association, actually filed judicial review proceedings against the government and NAWAC, again, this time challenging the Rodeo Code of Welfare. So just to give some brief information about that, so the 2018 Rodeo Code replaced the 2014 code and is materially identical to it. So the applicants are challenging the legality of the new code, the 2018 code, on both procedural and substantive grounds. So procedurally, the applicants consider that the proper statutory process was not followed in issuing the code. And these procedural errors include a failure to publicly notify the 2018 code, and as a result, a failure to consult on the code. And substantively, the applicants argue that the 2018 code permits activities that do not meet the purpose of the Animal Welfare Act. And the effect of this is that otherwise unlawful under the Act activities are treated as lawful in the code. So this is going back to that problem I mentioned, that or the question I raised, whether codes essentially just legitimize or legalize conduct that would otherwise be illegal under the Act. And the proceedings seek declarations from the High Court to this effect, that there's these procedural and substantive illegalities. So yeah, I mean, I think it's interesting just also to think about whether the judgment has significance internationally. It's certainly been referred to internationally, and it's part of a trend of countries that we're seeing banning or moving away from intensive farming systems such as farrowing crates. And when I last looked at the international picture, I think these crates have been banned in Norway, Sweden and Switzerland, and were being phased out in Germany. I haven't actually looked at the international literature for a little while, so that may have changed, others may have come on board. And in terms of the wider context, I think it's important just to note here environmental implications. Sir David Attenborough in the Netflix documentary A Life on Our Planet said half of fertile land on Earth is now farmland. 70% of birds are domestic, the majority chickens. We are 1/3 of animals on Earth. This is now our planet, run by and for humans. We're replacing the wild with the tame. If we act now, we can put it right. We must radically reduce the way we farm. We must change our diet. The planet can't support billions of meat eaters. If we had a mostly plant-based diet, we could increase the yield of the land. The public health implications, I think, are important to note as well in relation to these farming systems and this decision. Obviously, intensive animal agriculture is now widely recognised as a key risk for zoonotic disease. And I think, yeah, this obviously is well written about now and well understood that we need to rethink the way we produce food. And of course, the humane and animal welfare considerations. And just to say in this case involving pigs, who are obviously highly intelligent, sentient animals, and this decision is a really positive one for them, and is a reminder that we really do need to rethink our relationship with animals. So that's the end of my presentation. Thanks so much for for your attention, and happy to take any questions, or you're also very welcome to email me if you'd like to chat about any of this or any other issues about animal welfare, animal law in New Zealand. And just if you want to check out more about the applicants in the decision, those are the URLs for their websites. Thanks so much.
Thanks, Bianca. That was such an interesting presentation. There were a few comments in the chat that, the issues that you're facing in New Zealand are so similar to other ones, certainly in Australia being close by, but even in South Africa and other countries. So I think it's really exciting to hear that this could be a precedent for not only more cases in New Zealand, but other countries. We are running a little bit over time, so I might just ask that if anyone does have questions to Bianca, they could put them in the chat and maybe she can answer them there or via email, as she kindly suggested. And we might move on to our next speaker, which is Laura Smythe, who's going to talk to us about the US Endangered Species Act and how it's protecting animals around the world. So Laura is a senior staff attorney in the Animal Protection Law Department of the Humane Society of the United States, where she has worked since graduating from Georgetown University Law Center in 2014. Laura's practice focuses mainly on wildlife protection laws as she litigates cases in state and federal court, drafts petitions and regulatory comments to agencies, and advises clients on a wide variety of legal matters. Her docket includes issues such as domestic and international trophy hunting, wildlife trade, captive wildlife, marine mammals, government transparency, and animals used in research. So I'll hand over to Laura. Thank you so much for coming today.
Thank you so much. Let me just get my slideshow started. One second, sorry.
No, that's fine. It's always a bit
Sure, at the
fiddly.
beginning. Okay. I already practiced this.
Mhm.
Great. Can you see the slides?
Yes, that looks perfect. Thank you.
Wonderful. Okay, so thank you for that introduction. So my name is Laura Smythe. I'm a senior staff attorney in the Animal Protection Law Department of the Humane Society of the United States. I also represent our affiliate Humane Society International in a lot of legal matters. So you're going to hear about some cases that we have on behalf of both HSUS and HSI. And I'm here to tell you about how we use the US Endangered Species Act to help protect foreign species. So a bit of a quick agenda. I'm going to give you a basic overview of what types of protections the ESA provides, and a basic overview of what types of protections CITES provides, and tell you what CITES is for those of you who may not know. I'll try not to spend too much time on the legal background and talk about some cases that we have going on and how these two laws interact in practice, and some challenges and opportunities through that practice. So the Endangered Species Act, or the ESA, is a wildlife protection law that we have here in the US. It's administered by the US Fish and Wildlife Service, which is in the Department of the Interior within the US government. And under the Endangered Species Act, the service can list a species as either threatened or endangered. And depending on the listing status, different types of protections apply. So for endangered species, there are some automatic protections that apply. And some of the main ones I have listed here are take, which basically means to kill, harm, harass an animal. Also import and export, and also movement in interstate commerce, including selling an animal between states. And I will note that this import, export, and also interstate commerce is not just for a live animal, but also part or product of that animal, or a trophy, things like that. And there are some ways to get around that. You can get a permit from the Fish and Wildlife Service. One way to get a permit is to get an enhancement permit, which comes with this enhancement finding that the service has to make. And the enhancement finding is basically a finding, scientific finding by the Fish and Wildlife Service that says this activity enhances the survival of the species. So it's whatever it is that you're doing that would otherwise be unlawful, it's okay because it helps promote conservation, actively promote conservation. So for threatened species, it's a little bit less clear. The service has more flexibility with regard to what types of protections to put in place as is necessary for conservation of that particular species. So under Endangered Species Act Section 4D, the Fish and Wildlife Service creates these special rules, they're called, or sometimes called 4D rules. And there's flexibility within that to either apply all of the protections that you would normally have for an endangered species and require enhancement permits and things like that, or to provide some subset of protections. So CITES is the Convention on International Trade in Endangered Species of Wild Fauna and Flora. There are 183 parties to CITES. The US is a party to CITES, and within the US, the Fish and Wildlife Service administers that law as well. And the way that that law is implemented is through the ESA, and the Fish and Wildlife Service has CITES implementing regulations that it's legally required to follow that are law here in the US. So under CITES, kind of similar to the ESA, there's a listing scheme, but it works a bit differently. And CITES is really focused on trade and commercial trade and regulating commercial trade. So if a species is listed as Appendix 1, that's the strictest protections. For an import and an export, a permit is needed and a non-detriment finding is needed. A non-detriment finding is similar to an enhancement finding, but the standard is different, as you could probably guess from the name. For a non-detriment finding, there just needs to be a scientific finding that the activity is for a purpose that is not detrimental to the species survival, versus an enhancement finding where it's a stronger standard for the ESA, where it has to actively enhance survival of the species. And for Appendix 1, commercial trade is not allowed. For Appendix 2, there are fewer protections. You still have export permit requirements with non-detriment findings. Commercial trade is not banned like it is for Appendix 1 species, and there are no import permit requirements, which can be significant. These little icons here are a little bit of a clue of what we're about to talk about. So why is ESA listing needed? What we often hear from the Fish and Wildlife Service when we petition for them to list a species under the ESA, which I'm going to get into, is that it's no big rush. These species are protected under CITES, either Appendix 1 or Appendix 2, depending on the species. So there's no real urgency to listing under the ESA. But that's not true. There is urgency often. One of the main differences that I mentioned is the non-detriment versus the enhancement standards. Those can play out differently in practice. And then also for CITES, for Appendix 2, there's no import finding required. So for example, if say a giraffe trophy is exported from a range country in Africa, that country needs to make a non-detriment finding, but the United States has no responsibility, no legal responsibility at least, to make any kind of scientific finding to decide that that's okay for conservation. We also have some other issues with implementing CITES protections, including export quotas, which are frequently not based in science and are basically based in politics. And also countries can take reservations to certain listings, meaning that a country could decide we're just not going to enforce or implement CITES with regard to the species because we don't agree it should be listed. And additionally, on the ESA side, at the bottom here, we have some additional perks to being listed under the ESA. There's that interstate commerce prohibition, which becomes pretty important, and I'll explain why. And then also there's additional funding available for conservation. And I'm going to talk to you next about, well, first we'll get into what ESA can and can't do, and then some specific examples. Okay, so what's important to note, and a lot of our work focuses on trophy hunting, is that the ESA cannot prevent somebody from going to another country and killing an animal. That take prohibition that I mentioned, that really only applies with regard to jurisdiction within the United States. So the ESA can't prevent someone from going over to Africa, say, and killing a giraffe. What it can do is stop someone from importing that trophy, and that becomes very significant in terms of the impact that has on trade and demand. The ESA cannot stop someone from selling an animal within the state, although certain states in the US have started putting together some laws to restrict that activity, but it can stop someone from selling across state lines. And as I'm going to talk about in a moment with regard to a couple of different species, decreasing US demand can really have a huge impact on decreasing the number of animals that are killed. Okay, so I'm going to talk to you today about two species and some legal actions that we have going on. So the first species is the giraffe, which I just mentioned. Giraffes were recently listed on CITES Appendix 2. They were listed as vulnerable by the International Union for Conservation of Nature in 2016, and found that the population of giraffes has decreased by about 36 to 40% over the last 30 years. And part of the threat to the species is a threat from the US market. And between 2006 and 2015, more than 40,000 giraffe products were imported into the US, including over 3,700 hunting trophies, which is on average more than one a day. And this photo is from an US and HSI undercover investigation that we conducted in 2018 that just found a huge market for giraffe parts in the US. And this kind of goes into the importance of limiting interstate sale and limiting the movement of animal parts and products once they're here in the US. And some of the types of products, and you can see some pillows here, but it kind of ranged in terms of the grotesque creativity, I guess you could say, of what people have. Knife handles made out of giraffe bones, Bible covers, all sorts of things. So because they're listed under CITES Appendix 2, as I mentioned, there's no import requirements. And several range countries took reservations to that CITES listing, and we're still waiting to find out exactly what the impact of that is going to be on giraffe trade. So in 2017, we petitioned the Fish and Wildlife Service, we meaning HSUS, HSI, and some partner organizations, petitioned the Fish and Wildlife Service to list giraffes under the Endangered Species Act. They have no protections under the ESA currently. And when the Fish and Wildlife Service gets a citizen petition, it's called to list a species or change listing status of a species, it triggers some automatic deadlines. So the first deadline is this 90-day deadline to make a quote 90-day finding to decide whether the action may be warranted. And if that action may be warranted, then the agency has to make what's called a 12-month finding, which, as you may have guessed, is 12 months from the time they receive the petition to decide whether listing is warranted and then propose a listing rule. So we submitted the petition in April 2017. They failed to make any finding. We sued them in December 2018 for failure to make a 90-day finding. And they finally made a 90-day finding, agreed with us that listing may be warranted. So just last month, we filed a lawsuit against the agency for its failure to make a 12-month finding. It's been several years and the agency is well overdue, and that's a non-discretionary deadline. It has to make that finding within 12 months, and it did not. And what the Fish and Wildlife Service is saying to us in response is that they're planning to make a 12-month finding by 2025, according to this foreign species listing plan that they have, but they've already blown past their deadlines for other species. We think 2025 is way too far off for the protections that these animals need, considering the decline in the population and how active the US market is for this species. So we're hoping to get the court to order the agency to make a finding within a defined period of time. Right now, it's just kind of holding itself to this non-binding deadline that it made up. Okay. The next species I'm going to talk about are leopards, specifically African leopards, which is a subspecies. We have a couple of different legal efforts going on right now with regard to African leopard, and it's kind of an opportunity to understand how we work with like the CITES standards and the ESA standards and how they work together. So African leopards are listed under CITES Appendix 1. So that means import and export permits and non-detriment findings are required. So someone goes over to Africa, say Zimbabwe, kills a leopard, wants to bring its trophy home, it needs an export permit and non-detriment finding from Zimbabwe, and it needs an import permit and non-detriment finding from the United States. I will say that they're listed, so I say here, under the ESA, they're listed as endangered in part of their range and threatened in another part of their range, and I'll explain a bit what that's about. But leopard populations that the IUCN estimates that over the past 3 leopard generations, approximately 22 years, the populations have declined by 30%. One of the biggest conservation problems we have is that no one really knows how many African leopards there are. And that creates a problem when a country is allowing trophy hunting for them to not even know how many leopards are in their population to even be able to say whether it really is sustainable to offtake a certain amount. And leopards are facing other threats as well, but poorly managed trophy hunting is one of the threats that the IUCN has identified for leopards. And I'll also say that trophy hunting of leopards, it has a bigger impact than just removal of the individual animals that are being killed. We know that it increases conflict between leopards. So if a territorial male is removed from the population, then it can create conflict between the younger males that'll move in to try to take over that territory. Also, it can lead to increased rates of infanticide when an animal is killed and younger ones move in. And also there's some conservation issues around females being killed. In some countries, it's legal to kill females, and in others it's not. But we know that even where killing females is not legal, that's still a practice that happens. And in terms of the importance of regulating the US side of leopard trade, the US imports more than half of all leopard trophies that are traded internationally, which is usually amounts to a couple of hundred per year. So again, the US plays an outsized role here in leading to the decline of leopards, and specifically through trophy hunting. So as I mentioned, we have two different legal efforts going on right now. The first one, let me go to this slide real quick, is related to an Endangered Species Act petition. So we submitted an ESA petition. So sorry, first I'll explain what this graph is. So this is a red line that the agency came up with when it listed leopards under the ESA in the 80s, not based on science at all, kind of a compromise that they decided to come to. Above that red line, if a leopard is native to those countries, it's listed as endangered. Below that red line, the subspecies is listed as threatened. And what the Fish and Wildlife Service decided to do was to put in place a special rule, like I discussed earlier, and to automatically apply all of the protections that it would normally get if it were endangered, except there's an exemption for trophy hunting imports. So what that means is that there are no enhancement finding requirements and no ESA import permit requirements for specifically for leopard trophies for animals that are killed below that red line. So in 2016, we petitioned for two things. One, for the agency to list leopards as endangered throughout their range, to protect them throughout their range with all of the protections that the ESA would afford to endangered species. And alternatively, to give them this other option to change the special rule to get rid of that trophy hunting exemption, so that either way they would kind of come to the same result of leopards. If you want to import your leopard trophy, you need to prove to the Fish and Wildlife Service, the US Fish and Wildlife Service has to decide and find that that is actively enhancing conservation of the species. So we filed that petition in July 2016. They made a 90-day finding in November 2016, again, agreed with us that this listing may be warranted. Last year, we sent them a notice letter that we intend to sue them over not making a 12-month finding. They don't even have a draft kind of non-binding deadline for themselves of when they want to make that 12-month finding. So we've let them know that we're planning to bring them to court over that. And the other case I'll talk about in my next few minutes here is the case that we have challenging the Fish and Wildlife Service's CITES import permits and CITES non-detriment findings. So on the one hand, we had this legal effort to list them under the Endangered Species Act to try to get more protections, specifically to protect them from trophy hunting in that way. And on the other side, we have a case that's in federal court right now, basically trying to get the Fish and Wildlife Service to live up to its legal obligations under its regulations implementing CITES. So under the Fish and Wildlife Service's CITES implementing regulations, it is not allowed to just rubber stamp an exporting country's hunting quota or non-detriment finding. They have to do their own analysis, and there are certain legal factors they have to consider. So in December 2020, we sued the Fish and Wildlife Service over several non-detriment findings and CITES import permits for leopards that were killed in several African countries. Our lawsuit alleges that they have not considered the proper legal factors that they need to consider. They haven't used the best available biological information, which they're required to, and they simply don't have enough information to make that finding. The range countries themselves don't even have that information. Like I mentioned, like for a lot of these countries, there's really no reliable population data at all. Some countries are kind of doing some minimal monitoring, but there's a lot of missing information that we think is legally needed. And additionally, under the regulations, the Fish and Wildlife Service is required to take this precautionary approach if they don't have information and not make a non-detriment finding or make a negative non-detriment finding to say we cannot determine that this is non-detrimental to the species survival and conservation, and we allege that they're not doing that either. So I will say, like, the CITES export quotas for African leopards, like for many other species, are just not based in science at all. The export quotas are kind of agreed to by the parties to CITES, and it's basically kind of political maneuvering. And there's really no biological basis to any of this, which is incredibly worrying. Okay. I think in the interest of time, I'm going to stop there and see if anybody has any questions.
Thanks so much, Laura. That was great and really interesting to hear about. Can I ask really quickly, and sorry if I misunderstood because I'm not so familiar with this area, but you mentioned that you were going to take someone to court over the leopard situation, the fact that they sort of haven't got a time frame in place for what they're doing next. Can you talk a bit more about how that will work and what that lawsuit might look like?
Yeah, so we filed a similar lawsuit for the giraffes, and we haven't yet filed our lawsuit over leopards, but we are planning to, as we told the service in our letter last year. And basically that's a lawsuit that's so for the leopards, it's actually a little bit more, I think, interesting, maybe complicated, in that we have the ESA ask, the pure ESA legal claim of you are required under the ESA to list a species to make a 12-month finding within 12 months, and you haven't done that. And that's a pretty straightforward claim. There have been several cases brought in the past couple of years where the agency has admitted, I mean, they really have no legal defense to that. It becomes a question of remedy for the court. And sometimes these cases settle for a compromised deadline, but there's been a couple of cases in the last couple of years that the parties have basically briefed for the court, what should the remedy be? Everybody agrees that the Fish and Wildlife Service violated the law, but practically, what kind of a remedy is the court going to issue? And by remedy, in this case, it would be a deadline. So we'll have to wait and see kind of what deadline, how deferential the court would be to the agency. It'll become kind of a battle of whose deadline is more reasonable, given the conservation implications and the urgency of it, but also given the Fish and Wildlife Service is certainly going to argue that they have a big workload and all of these types of things that we're kind of expecting them to say. And then the other side of that is we have this petition that I mentioned to change the special rule to get them to get rid of the trophy hunting exemption. And that one, the way that claim would work kind of practically under US law is that it wouldn't be brought directly through the Endangered Species Act. It will be brought through a law we have called the Administrative Procedure Act, basically alleging that the Fish and Wildlife Service failed to respond to our petition within a reasonable time. It's been over 5 years since we submitted that petition. So that's kind of, yeah, it's been over 5 years. We have no 12-month finding. We have no substantive response at all to our petition regarding the 4D rule. So we've certainly been patient enough and given the agency, time. When we told them a year ago that if they didn't get their act together, we're going to bring them to court, which is something, by the way, that's legally required. If you bring a lawsuit into the ESA, you're required to give some notice to the agency ahead of time in case they decide they want to change their mind and comply with the law, which they have not decided to do.
Yeah, thank you for that. We've just got another question in the chat from Marisol, which says, what will it take to get the US Fish and Wildlife Service to prohibit the import of certain trophies such as rhino, leopard, lion, giraffe, if they're not taking this as seriously as it is?
Yeah. I mean, that's a really good question. I think there are some species that are listed that do have enhancement finding requirements, and the Fish and Wildlife Service still decides to issue enhancement permits. And it's a really big problem. And I think that what it's going to take is, either a lawsuit from a group like us to get a court to say, like, no, that's not reasonable, or hopefully, what would be a smoother path would be just some change in, leadership within the agency or within the Department of the Interior. And unfortunately, across administrations, we haven't seen that much of a difference in terms of the Fish and Wildlife Service's position on trophy hunting, and it's not very friendly to animals. So I think this is one, a legal issue of organizations bringing the agency to court where possible, and also a political issue of people, voting for folks that are going to make change and really take conservation seriously.
Yeah, no, thank you. And it's a shame that it takes sort of, groups putting in, a lot of time and cost and having to actually take these agencies to court to get anything done. But you're doing amazing work. So thank you so much. And thank you for your presentation today. We really appreciate it. So we're going to move on to our final speaker of today, and that's my co-host, Tony Gerrans, who's going to be talking to us about the legal challenges to live animal export. So I'll give Tony another introduction. Tony has worked in government, private business, and the not-for-profit sector, primarily in agricultural and animal welfare fields. As principal planner in the Restitution Research Directorate of the South African Department of Land Affairs, he was part of the team researching and advising the Post-Apartheid Commission on Restitution of Land Rights on the legal validity of land restitution claims filed by victims of South Africa's racially based separate development policy. He's also served as a trustee of the Humane Education Trust, the South African affiliate of Compassion in World Farming, and currently serves as legal advisor on the Cape Animal Welfare Forum. He's completed his master's in animal law at Lewis and Clark Law School and is now working with Humane Society International as their executive director of African operations. So Tony, I'll hand over to you.
Thanks, Tess. Let me just call up the presentation. Can you see it displaying correctly?
Yes. Yes, we can see it there. It's just in we can see all your slides down the side though. You don't know if you want to put it in a presentation mode. Yeah, that's perfect.
Okay, thanks. So we had quite a long session and there's lots to talk about in live export. So I'm going to go relatively quickly in the first half where I'm going to talk largely about the harms of the trade and why it's problematic. And after that, I can slow down a little bit and talk about the legal efforts in South Africa and the lessons we could learn from that. So live export by sea for slaughter is highly problematic practice of transporting tens of thousands of animals en masse on ships from one country to another for the purpose of slaughtering them at the destination. The global trade in live farm animals transported for slaughter has more than quadrupled in size over the past 50 years. Every year, nearly 2 billion farmed animals are loaded onto trucks or ships and sent to other countries in journeys that can take days and sometimes weeks. And on any given day, at least 5 million animals are in transit. In 1988, the global trade in live animals was worth $716 million. By 2017, that number had risen to $21 billion, according to Comtrade data. So the species most traded are pigs, chickens, cows, sheep, and goats. The top importers of farmed animals are the US, Saudi Arabia, Poland, Italy, Hong Kong, Turkey, and Qatar. And the top exporters are Denmark, Netherlands, Canada, Sudan, Australia, Spain, and Romania. The major trade routes for animals are into and around Europe, from China to Hong Kong, from Australia to the Middle East, and from South America up to the Middle East as well. And the rationale of this trade really is an incentive to move animals alive rather than refrigerated transport in order to reduce costs. The problems we have is that the welfare is largely unregulated and that these shipping lines really are exploiting the economies of scale in order to drive down the unit cost per animal transported. So why are animal protection advocates concerned about welfare in the live export trade at all? There are both routine systemic harms that animals suffer in the trade and also a horrific record of disasters on live export ships. There are about 139 livestock carriers currently operating. The average life of the current fleet is around 37 years. The oldest ship on record currently is 56 years of age. More than 50% of the fleet was built before 1980, which makes it the oldest category of commercial maritime shipping fleets, classes around the world. Average age of the ship is 38 years compared to a container ship average age of only 13 years. And most significantly, 52 vessels, around a third of the operating fleet, sail under flags of convenience from states which are blacklisted by the Paris MOU agreement, which addresses commercial ship inspection. Age is not the only problem for these ships. Many of them were never built to handle animals in the first place. Most are converted ro-ro or general cargo ships with inappropriate architecture for animals, such as hard floors, inefficient ventilation, and so on. They are prepared for not being near the docks. They're usually transported in large numbers from that feedlot to the docks by truck and are loaded onto the multi-deck vessel by means of ramps. Given the large numbers of animals being handled in a relatively short period of time, injuries can result from falls, trampling, and/or manhandling. On previous journeys from South Africa, for example, loading took place through the night, and according to the National SPCA, the handling of so many animals in such a short time can and did result in abuse, such as animals being dragged by their limbs, horns, or fleece. It's almost impossible in these circumstances to isolate pregnant, injured, or diseased animals when handling such large animals in such a short period of time. Most ships have steel floors, which are completely unsuitable for hooved animals that are meant to stand on soil and who now have to spend up to 4 weeks on a moving vessel. Animals are exposed to constant noise from the ship's machinery and ventilation system, and often as well as constant light, despite their need for darkness in order to sleep. Although sheep, for example, are accustomed to eating grass, they are usually transitioned to pellets before boarding, and some have digestive issues which worsens an already poor hygiene situation on board, with animals typically living in their own excrement for the entire journey. Animals with pre-existing skin issues or those who incur injuries during transport and loading often suffer infections exacerbated by the poor hygiene on board. Inadequate ventilation and the accumulation of waste results in high levels of ammonia and hydrogen sulfide gas and causes respiratory complications, especially for cattle. The feeding and water troughs on board are usually automated. Some animals cannot get access to these and starve or suffer dehydration, and others refuse to eat during stress, and they also starve or possibly dehydrate. In crowded conditions like these, injured animals who have given birth on board cannot be detected, and newborn lambs and weak animals are often trampled or crushed. The Almacila, a converted car carrier which can carry up to 85,000 sheep, was the subject of welfare litigation in South Africa. It's comprised of multiple closed decks, all containing small pens in which sheep are tightly packed. It's impossible for any single person to inspect all the animals en route, especially those at the back of the pens. The number of crew on board is usually inadequate to ensure that all the animals, especially those at the back or the weaker ones, are able to reach the food or water. Most animals are denied even the most rudimentary veterinary care during the entire journey. Compromised animals, even if they were found, would not receive adequate veterinary care. Onboard vets on voyages from Australia have reported facilities on ships to quarantine and treat injured or diseased animals as wholly inadequate. Ventilation is also inadequate for the number of animals often kept below deck, and it cannot mitigate the tropical conditions vessels often face when transiting the equator and entering the Persian Gulf, for example. The steel walls of the ship and the warm ocean amplify heat and humidity on board, and this combines with the heat that the animals are producing. Some species, again, such as sheep, cannot thermoregulate in conditions of high temperature and humidity, and this is made worse because they are caked with a fecal jacket. Severe heat stress and dehydration can lead to organ failure. Animals often collapse before suffocation in their own excrement, or they trample to death. Undercover footage detailing torturous conditions and suffering on ships has led to Australia banning the export of live animals during the summer months. And then the animal's distress continues often after the voyage has ended. Offloading large numbers of animals in a short time puts them at risk again of being injured because time is tight. The sheep's or cattle's welfare is often uncertain after arrival at their destination. It's often not known where and how the animals are kept or treated once they leave the ship, and many destination countries lack animal protection legislation, such as the Animals Protection Act or Animal Welfare Act. Unlike Australia, South Africa has no regulatory constraints yet on how these animals are treated at destination. The toll on animals is enormous. Just to give you an idea of the numbers, Animals Australia estimates that over 2 million sheep have died at sea on the route between Australia and the Middle East alone. The industry itself doesn't publish any meaningful metrics about welfare, instead using mortality statistics as if the number of animals dying whilst in your care is a good way of measuring suffering. Some exporters claim 2% mortality is an acceptable target per voyage, meaning that on a ship carrying 80,000 animals, 1,600 will suffer so seriously that they actually die, and that this is deemed an acceptable yield. Then we have the problem of off-nominal events or disasters. The nature, age, and design of livestock carriers mean that accidents on these vessels are often fatal for the animals on board. The Gulf livestock ship with 43 crew and nearly 6,000 cattle capsized and sank off the coast of Japan on the night of September the 2nd, 2020, after reportedly losing an engine in rough seas. Only 2 crew members survived, and all 6,000 cattle were crushed or drowned in the sinking ship. This is just the latest in a history of disasters on board livestock carriers, which have been capsizing, grounding, and catching fire out their entire history. In 2019, Palau registered livestock carrier Queen Hind with 14,000 sheep on board developed a list, capsized, and sank in Medea, Romania. The vessel was resting on its starboard side with half the hull remaining above the water. The 22 crew were rescued, but only 180 of the 14,000 sheep were saved, having been found swimming in the sea, the rest suffering a terrible death by crushing and drowning inside the flooded vessel. In 2019 and in 2017, nearly 3,000 sheep died of heat stress on 2 different voyages en route from Kuwait to Australia, en route to Kuwait from Australia. The livestock carrier Haida capsized in October 2015 while berthed in Para, Brazil. Thousands of cattle were trapped on board and perished. The Haida was built in 1994 as a container ship and was later converted to a livestock carrier. The 1972 Panama-built Nabalsi 1 caught fire in the autumn of 2020 in the Med off Crete. It was on its way from Beirut to Alexandria. In the 1980s, 40,000 sheep burned to death on a single ship sailing between Tasmania and Iran. In 1996, 67,000 sheep were killed on a fire in the Indian Ocean when a ship sailing from Australia to Jordan was abandoned by the crew as it burned. These horrific events speak to the practical impossibility of evacuating tens of thousands of terrified animals from a compromised vessel, and to the ongoing danger that the aging and poorly designed fleet of livestock carriers poses to animals transported in this way. Animals transported by sea are not protected by any international law addressing welfare whilst the ship is on the high seas. Multiple incidents have led to some countries like Australia projecting welfare standards through the shipping supply chain by using the contractual conditionality in export permitting regimes, and in some instances have supported this welfare minima with compulsory reporting and inspection requirements. But for the most part, shippers are free to conduct their trade with little legal oversight, especially when on the high seas. The World Organization for Animal Health, the OIE, is the agency responsible for setting standards on public and animal health and has a role in creating rules for animal welfare. But it's not responsible for ensuring that these welfare guidelines are adhered to or for punishing anyone who transgresses them. This is still down to individual governments. There is no international inspectorate nor compulsory welfare reporting. Enforcement of export regulations is nearly impossible to assure in practice. There's not even an international welfare metric to gauge standards on board, with the industry citing the aforementioned mortality statistics in a bizarre measurement of animal well-being. Although South Africa has been exporting live cows to Mauritius by sea for some time, the scale of the industry ramped up quickly from 2018 onwards when a large global operator based in Kuwait started exporting sheep from South Africa. In 2019, KLTT, the shipping subsidiary of the Kuwaiti meat company Al Mawashi, commenced shipping operations of live sheep, cattle, and goats from London and South Africa to Kuwait and Oman. Efforts by the local Al Mawashi subsidiary to have the NSPCA endorse the exports were unsurprisingly unsuccessful. Both the Eastern Cape Provincial Government and that province's Economic Development Corporation were both strongly in support of live export, and after some ambivalence, the National Department of Agriculture also came out in support of live export. Concerned welfare organizations, the Muslim Judicial Council Halal Trust, the South African Veterinary Association, and a raft of others have all made public statements condemning the practice, noting that the known welfare harms cannot be addressed on board and the export business will have as yet unquantified negative impacts on local animal and meat processing value chains. The National Council of NSPCAs then launched a series of court applications to interdict export shipments, which after some initial successes have so far been largely unsuccessful. The South African Department of Agriculture, now called the Department of Agriculture, Land Reform and Rural Development, undertook as far back in 2013 to develop regulations to assure the welfare of animals on long-distance transport. This hasn't yet been completed. The NSPCA thus looked to our domestic anti-cruelty legislation, the Animals Protection Act, which in section 21M makes it an offence to convey or confine any animal in conditions which causes unnecessary suffering. These are exactly the conditions that animals are likely to endure on vessels from South Africa to the Gulf states of Kuwait and Oman. The NSPCA laid criminal charges against persons involved in handling of these animals in the process of transporting them from feedlot to the docks and loading onto the vessel. And the NSPCA also brought an application in two parts before the Grahamstown High Court, asking in Part A for an interim ban on live export across the equator, brought on the urgent roll, and in Part B, asked for a permanent ban on all live exports on the same basis across the equator. This strategy seemed to be seeking a ban based on the allegation of unavoidable suffering on board induced by heat stress. The NSPCA court documents did not seek to establish the other types of harms, such as injury, infection, and starvation, which would also amount to contraventions of the Animals Protection Act. The challenges, of course, that they faced in this litigation were firstly establishing urgency. I think each country has slightly different rules for that, but there's a number of tests that have to be met in order to get your matter heard on the urgent roll. Then they were asking for an interim interdict, and there is essentially a balancing of harms process that the court will have to consider in that regard. They have some real difficulties in producing reliable evidence of suffering at sea on journeys from South Africa to Kuwait, because they are not allowed on the voyages, and nor are any independent inspectors allowed on board, which required then that the NSPCA relied on information supplied to them from journeys between Australia and the Middle East instead. There's this question of proving what is unnecessary suffering in terms of the Animals Protection Act. And then finally, this litigation with 12 respondents incurred significant costs, and an adverse cost order, even in public interest litigation, is always a concern, especially when litigating animal protection matters. In ultimately denying the NSPCA's application for the interim ban on live export from South Africa to destinations across the equator, the Grahamstown High Court ruled that the Almasila vessel could sail, but with no more than 56,000 sheep on board, and such sailing would be subject to certain conditions. These conditions were essentially that the Department of Agriculture must ensure that Chapter 7.2 of the OIE Terrestrial Welfare Code, the one dealing with welfare of animals in live transport at sea, must be complied with. Immediately after the judgment was handed down, and I mean immediately, the loading of the vessel commenced, and within days it set sail. And after the department had duly filed the affidavits which attested to the OIE compliance. There were no reasons proffered for the judgment, though the court undertook to make these available in due course. The judgment's notable for a number of reasons, although it seems to give some weight to the possibility of animal suffering on board, for example, by reducing the stocking density to mitigate heat stress. It totally ignores the Animal Protection Act, which is the principal statute governing offences against animals in South Africa. Instead, the judgment cites the OIE Chapter 7.2 as the normative baseline for animal welfare in this instance. The court similarly ignores the statutory mandate of the NSPCA in inspecting and prosecuting animal welfare violations, and instead makes the National Department of Agriculture responsible for assessing welfare compliance during loading and for assessing the arrangements made on board to assure welfare during the journey. This is also odd, as the department has no animal welfare inspectorate and has and continues to make little effort to assert and enforce animal welfare standards in any other agricultural context. Indeed, until a recent unrelated judgment made state responsibility in this context plain, government departments in South Africa have been actively repudiating responsibility for animal welfare inspection and enforcement. And what should we make of the court's reliance on the OIE code instead of the APA? Perhaps the judge was worried that the Animals Protection Act had no binding jurisdiction on a foreign-owned vessel sailing outside of South African waters, and he could thus not apply the provisions of the Act to anything other than the domestic transport and loading component of the journey. But the OIE Chapter 7.2 is really not a detailed set of welfare regulation at all. It's expressly written as a guideline for how such regulations should be set up by a responsible authority. As Professor David Favor, Professor of Animal Law from Michigan State University, has noted, a review of the adopted OIE standards on live animal transport will reveal their significant limitations. The standards include no numbers, no prohibitions, no required inspections, and no limitations on operations. Rather, the standard is like a checklist of issues that should be considered if you're going to engage in live animal transport. Whilst this list is useful for policymakers, it's not an actual standard that limits or prohibits practices that are harmful to animal welfare, nor can it be expected to do so, as the OIE is not charged with such an important responsibility. The subsequent published reasons for the judgment offer little to help clear up these issues. The judge complains that the NSPCA filed too many papers, but then goes on to be critical that the NSPCA ignores the OIE code. He addresses the mandate of the NSPCA to investigate and prosecute cruelty to animals, but fails to explain why he then ordered the Department of Agriculture to take on the role in this instance. He recognizes the prohibitions of cruelty in Section 2.1 of the Animals Protection Act, but gives no coherent explanation as to why he did not apply these standards and instead gave deference to the OIE provisions. A review of the affidavits filed by the department asserting OIE compliance, which purported to satisfy the conditionality which allowed the ship to sail, raises still further questions. The affidavits concede some non-compliances with OIE loading guidelines, which should then have prohibited the sailing of the vessel. There's also no detail whatsoever of how the circumstances of the imminent voyage were assessed to be compliant with the provisions of the OIE code as a whole. As noted before, the OIE code is not adequate in itself to protect animals on the ships, but it does require certain basic disciplines, such as proper stockmanship qualifications for persons handling animals, contingency plans for the voyage, vessel design and operation, species-specific aspects of animal care on board, and so on. There's no evidence whatsoever in the affidavits that these efforts were engaged with substantively in the department's discharge of the role the court assigned to it, nor have these substantiations been forthcoming from the department in subsequent inquiries filed under the Promotion of Access to Information Act. It's my view, therefore, that the court order does not correctly apply the law, though the NSPCA has not been able to have it overturned on appeal. It seems clear as well that the journey in question did not comply with the conditions of the court order at all, as the department did not correctly discharge the responsibilities assigned to it in evaluating and confirming that the journey would be compliant with Chapter 7.2. To the extent that it may be argued that future journeys should thus also be permitted only if compliant with the provisions of Chapter 7.2, there may be a basis here to challenge the lawfulness of future sailings. Interestingly, subsequent to these court proceedings, the National Department of Agriculture finally published its own live export welfare guidelines for comment. These guidelines precluded shipping of animals by sea into the Northern Hemisphere summer, exactly the welfare concern that the NSPCA raised in its application. These guidelines have not been formalized into regulation, and shipments into the Northern Hemisphere summer have been permitted, despite the department's own acknowledgement that these are harmful to the animals concerned. So some of the legal options that could be considered further would be to try and ensure this adherence to OIE Chapter 7.2. As mentioned earlier, there is no inspectorate or enforcement mechanism, making it very difficult. The Animals Protection Act seems to be limited by its lack of extraterritorial jurisdiction, and there are, of course, issues with documentation and independent oversight and the collection of the necessary evidence. The local regulations specific to live export welfare at this stage are guidelines only. As I mentioned before, they're inconsistent with the current practices, and it's unclear whether the minister even has the power to delegate these type of regulations under the Animals Protection Act at all. There are other public policy pressure points that advocates could possibly apply to frustrate the trade in live animals, such as the questions of public health, both diseases of humans and animals, the economic considerations of shipping live animals overseas as opposed to processing them in South Africa, and of course the question of trade agreements that we touched on earlier when talking to Martina. There are some international developments which have started to give some basis for hope that national governments might indeed be starting to recognize the harms of live export by sea. The Ministry of Primary Industries has announced that live export by sea for slaughter will be ended from New Zealand by 30th of April 2023, and similar prohibitions are under consideration in the United Kingdom, and the EU is actively looking at better regulating the trade. Although political campaigning continues in many countries around the world, without a proper international policy or legal instrument, there is a danger that the trade continues to expand by pivoting away from countries with better regulation and or live export bans, and gathers traction in jurisdictions like South Africa, where the governments are unable or unwilling to regulate meaningfully to protect animal welfare. In conclusion, then, the following points seem evident. The nature of confining large numbers of animals on an ocean-going vessel and long distances on the high seas creates inherent welfare harms that simply cannot be avoided. The lack of independent oversight on board means most suffering goes unrecorded. The old fleet and the inability to evacuate vessels provides additional risks to animals in the event of disaster. Many of the countries that trade in animals have poor domestic welfare legislation, leading to concerns, especially over welfare at destination. Chapter 7.2 of the OIE Code really provides no meaningful protection for the animals whatsoever. And around the world, activists are seeking a ban, but at this point, it seems that regulation is more attainable. And restrictions to the trade seem to me to be more likely to be achieved through a political process rather than through anti-cruelty litigation. I think those who work in farmed animal welfare will know that most farmed animals live pretty miserable lives. The least we can do at this point is to not worsen this by subjecting them to yet further suffering by transporting them live around the world only to be slaughtered anyway for our short-term financial expediency. I think we're out of time, so I'm going to stop there and see if there are any questions or if anyone wants to discuss the matter further. Thanks, Tess.
Thanks, Tony. Thank you for sharing that. And obviously, live export's a big issue here in Australia. I can see we've got a comment here from Marisol in the chat saying, it is worth noting that the exporter also mounted a massive PR offensive in South Africa, falsely claiming on issues such as job creation and food security as part of a misinformation campaign, in addition to attacking the NSPCA. It's interesting, I mean, we have a similar issue in Australia where the industry is, a powerful lobby group, but at the same time, we have an interesting sort of alliance between animal welfare groups and the meat packers industry basically in Australia, because they see it as, losing out on jobs. If we're slaughtering these animals overseas, then it's missing out on jobs here. So I'm not sure that argument about job creation is really a valid one. What do you think, Tony?
Well, we know in South Africa that the minister has asserted that this is a net creator of jobs, but some very preliminary research has shown us that whilst jobs have been created in the Eastern and Western Cape provinces where some of these animals are being sourced, other provinces such as the Northern Cape have suffered significant job losses. And in fact, slaughterhouses are being shuttered and staff are being retrenched there. So the net benefit at this point is unclear. And we have submitted a FOIA application to the department to ask for the minister's research to assert that this is in fact a job creator. I think that the concern we're worried about is that the export trade expands to the point where the South African industry is compelled, like in Australia, to export in order to sustain the jobs and to sustain the livelihoods. Then the trade becomes much more entrenched and becomes really difficult to stop. I don't think we're at that point yet, but there certainly is a trade-off where one area is benefiting and another area is being harmed. Interestingly, the company that is exporting the sheep from South Africa started first here by procuring and exporting chilled meat. So their business was at the outset leaving the processing and the beneficiation and the value added that comes from that in South Africa. But that has changed quickly, and they're talking now of expanding this trade up to 600,000 sheep and nearly 1 million goats a year, which will be a significant portion of South Africa's production. And Farmers Weekly has reported that it's been a major driver of the increase of cost of sheep products in South Africa, that the export is in fact creating net shortages in South Africa. So the economic case is not clear, even though Marisol's right. The company has launched a massive PR offensive asserting that it's creating jobs, particularly for emerging farmers, and thus meeting the political requirements in South Africa of promoting transformation in the sector. But we haven't seen any evidence to that yet.
Yeah, it's interesting because yeah, obviously we have a huge industry in Australia, and you know, it's kind of bizarre because, you know, it's sort of similar where, you know, there is an economic argument to be made, but it doesn't seem particularly powerful. So it makes you wonder why the government is continuing to allow this industry compared to, you know, other industries. I wanted to ask you, going back to your presentation, about whether we should be focusing on like increased regulations for the industry or just focusing on trying to get a ban. I mean, obviously in Australia, we have managed to achieve some additional regulations, like, you know, the ban on exporting during the summer, although they've still allowed ships to go in the summer regardless. And we've also managed to get the independent inspectors on board, although those were suspended during COVID. It sort of seems like I guess it goes back to a more fundamental argument about how we should best advocate for animals, but it almost seems like sometimes those things are just ways for the government to say, oh, look, we've cleaned up the industry, it's all fixed now, we've got an independent observer on board, so no need to ban it. You know, is it worth focusing on those kind of small regulations and incremental improvements when we know at the end of the day it's really not going to make a difference to, you know, the lives of these animals?
I don't know, Tess, that's a good question. I think at this stage, the asymmetry between the resources that are brought to bear in promotion of the trade and the animal welfare groups trying to stop it really render a outright ban totally out of reach, including now the precedents possibly that this NSPCA litigation has set, and you know, simply just the difficulties of trying to establish the harms of live export on journeys from South Africa. So I think at this point, the regulation is in fact the only option, practically speaking. Good regulations presumably then would frustrate the trade to the point where the alternatives might, you know, might become again economically valid. And you know, Vincent has asked in the group, why is exporting animals cheaper than exporting processed meat? And you know, I don't really know the numbers to that. It may well be the question that they are treated differently from a tariff point of view. I think simply there is almost no regulation of the live export trade, as opposed to quite significant regulation for meat products. So I think practically speaking, what is required is global coordination to try and deal with this trade at different ends. There is no purpose served by Australia stopping it and having the trade come en masse to South Africa. You know, we're still in the end got the same number of animals at sea. So I think, you know, I think we have to try and work with what we have at this point. And the government regulations are incoherent. And perhaps the fact that they have admitted that the trade needs regulation, but then have produced irrational regulations and don't abide by those regulations, gives us a new cause of action. Instead of having to argue the welfare issues, we basically say it's settled that there's welfare issues. You've admitted that. The question is, have you dealt with those welfare issues? And I guess that's going to be our strategy going forward.
Yeah, no, that makes sense. There's one, probably got time for one more question, which Bianca's just asked, is that she's asked if there's much public opposition to live export in South Africa, and she thinks that in New Zealand, the sustained protests against live export made the issue a lot more visible to the public, and she believes hopefully contributed to the ban that New Zealand's just imposed. I mean, how much public opposition and campaigning is going on from the political perspective?
Yeah, there is a small coalition working to try and increase the profile of the trade. It is actively countered by the exporter, who spends a lot of money on setting an alternative narrative in the media. So the short answer to Bianca's question is the public opinion and resistance to this is at this stage wholly inadequate to have any type of political impact. I think what is required is things like boycotts of local products from companies that are exporting so that it affects the revenue streams of those businesses. I think far more publicity is required about what is really going on, and some detailed study into this question of whether this is in fact meeting South Africa's broader political goals of poverty alleviation and the transformation of the agricultural sector, because at this point, those arguments are just asserted and are not produced with any type of factual validation. So lots and lots of work to be done there. The other thing to consider possibly is that the red meat industry, through its industry association, seems quite concerned that live exports might further tarnish the reputation of the red meat industry as a whole, and it might then yield market share to chicken or fish or eggs, for example. And so that might be an angle to campaign on. And they, in fact, joined the litigation as a party, and it was their proposal that the court ultimately accepted as a compromise position. So they seem to be the kingmakers in this at the moment, and perhaps there is a lobbying solution there that might allow for some progress.
Thanks, Tony, and thanks everyone. We're probably at the point of the day where we need to wrap up. I'm sure everyone will agree that it's been a really fantastic session. The speakers have been so interesting and provided really interesting and different insights into the work that they're doing, and hopefully provided everyone some good ideas on other things they can be doing in their home country or to be thinking about in the future. So I want to thank all our speakers so much, and thank the Centre for Animal Law Studies again for their support. As we said, we have been recording today's webinar and we hope to make it available online. So we'll post about that in the Facebook group for the event when it's available. So yeah, on behalf of Tony and myself, thank you so much everyone for coming today, and yeah, have a lovely day, evening, whatever time zone it is for you. Thanks so much.
Thanks for having us.
Thank you so much.
Thank you.
Everyone, thank you. Bye.
Bye.